I beg to mention item number 9 and 10. Yes, I have taken the consent. Kindly, this matter may be adjourned for today. 9 and 10, yes.
On the prayer of Mr. M. Kaba,
Kamba,
Land
yes.
Council for the petitioner, the matter is staying adjourned to be listed after a week.
Yes, after a week.
After a week, okay.
Bless.
None appears on court. List after a week. Okay. Next week, Monday.
I beg pardon, item 1.
Item 1.
Item 1, Lordship.
Okay.
Lordship, I beg that inadvertently I made wrongly mentioned index in my petition, index copy, and wrongly mentions civil CRP, where it should be in WPC, read petition.
This is otherwise?
Index and page 1 only. Rest is okay. So I may allow to correct it.
Where you want to correct?
Page 1. In place of 226, only 7, only 1 digit. 7.
Index.
Yes.
Which one you want to correct?
Page 1.
Page 1.
Page 1.
Petition.
Yeah, petition, page 1. Just 227. In place of 227, I may allow to correct 226.
Okay.
And
only that much?
And lots of index here in CRP I have mentioned wrongly, inadvertently mentioned this CRP. These 2 things only. So I may allow to correct it.
Where you have mentioned? CRP?
CRP civil revision petition.
No, where have you mentioned?
Civil miscellaneous jurisdiction.
Okay.
Index. So what's I may allow to correct it. Inadvertently mistake has done by me.
Mr. Regam, Land Council for the petitioner. Some is that inadvertently he has met where?
Index copy this in place of the WPC I mentioned CRP.
Okay, he has written page number 1.
Index and page number 1.
WPC in place of CRP.
Yes.
Therefore, praise for allowing him to correct the same. In that case, since it is not allowed to correct in the page, then you have to replace it.
That's
okay. The prayer is allowed. The petitioner shall file an amended this page, index page.
Index and rest is okay. Only index top civil revision, civil miscellaneous jurisdiction, civil revision.
And the page number also.
Yes.
Okay. File the corrected. Corrected. This is index.
Index only.
Okay. The registration due and needful. No. Okay.
That's
Okay. Then it will be listed thereafter.
if allowed, then it may be pass over. I will correct it. Pass over. I'll correct it.
No, you have to. I think this is to be replaced.
Okay, I'll replace.
Then when this to be listed?
Listed tomorrow.
Tomorrow. Okay. Okay, and list it after the Well, after the amended interim is filed. Okay.
No, sir. Highly valuable.
Time being.
I'm assuming the impute order dated 2nd May 2025. First by the Session Judge UPM. This case, correct court below has compounded the matter without the consent of the complainant.
Compound the
Case without the consent of the party. Mal will find impute order is dated 2nd May, it's page number 31. Operating portion is it
just a minute. Yeah, you have those. Okay. Then I guess it's a compounded.
compounded without
Where do we find that? Your relevant portion?
page number 34 at para
Yes.
12 and 13.
34.
34.
Okay, the earlier order.
Earlier order is
huh?
there is a
The trial court order is that
it is,
this was against respondent.
yes.
And then against this, they have filed
Appeal.
appeal.
Appeal. Without even giving the parties now. A motion states there. Without issuing notice to the parties. That the court below is directly impounded on it.
Where is the operative portion?
Page number 34 at para 12 and 13.
What happened thereafter? The respondent has deposited the amount.
Apparently, I have been informed they only deposited 5 lakhs.
So the total amount was not only 5 lakhs, it appears in the judgment. 5 lakhs plus
5 lakhs fine.
and fine, whether the fine has been deposited.
Okay,
What about the fine?
it has not been deposited yet.
Is there any direction in the impute order to deposit the fine also?
They only seized 5 lakhs.
And 25,000.
Yeah. 25,000 and 15%, which comes around 75,000. Altogether, 6 lakhs.
Okay, not the fine, rupees 5 lakhs,
Yes.
fine of 5 lakhs. No mention of the fine.
Yes. Well, this observation, it is completely the judgment rendered by the Apex Court, which says compounding and opens for consent of the parties is mandatory.
The motion stays
Yes.
without issuing notice.
Okay. But I have one citation, Malu. If Malu allows me. It says, Malu, it is essential for the court
I thought this is against the judgment of the trial court, but this is against the appeal. This was disposed of on the day when it was moved.
Yes.
No one was represented. Yes. Yes, Miss Jenny, what do you say?
Your Lordship,
This, I thought this is against the trial court order,
yes, Your Lordship.
where
It's an
the
appellate,
amount and the fine also was directed. But then it appears that
but then since it's an challenge to the criminal appeal, Your Lordship, my concern is only with if this petition is maintainable as a criminal petition or not, because
Mhm.
any order challenging the appeal, Your Lordship, has to approach before the apex court.
This is revision.
Not, this is a criminal
revision.
petition, not revision.
Issue here is, what happened is, by this appeal order, matter has not been finally adjudicated.
No, that is there. Whether then it's a criminal petition.
Yes, Your Lordship. And any
Not
order of the appeal, be it the judgment or the miscellaneous orders, Your Lordship, has to be challenged before the apex court otherwise.
It won't lie against any interlocutor.
Hmm?
This order,
Hmm.
it won't interlocutor, because it has not been finally adjudicated. This is the issue, therefore, this petition is filed. And now, this order itself is jurisdiction, therefore, this petition lies.
No, Your Lordship. This, in fact, if Your Lordship will see page number 34, where the appeal has been disposed of, there is no any doubt with regard to if this is a final order or not. This is a final order, Your Lordship. And if any final order is to be made, it has to be.
Our 13 month says, learn it, various. We have to notify. COVID execution.
Hmm.
Therefore, it is quite in. tendency.
What is the citation which you wanted to show? What is this
Paragraph
about?
17.
Hmm?
17. Page number 4.
This was passed in,
Person A's formatting.
just a minute.
It is of 23/7/2020. In NI case. Same case.
This is also an answer.
Yes.
Just a minute. Page 17, para 17.
Parasa,
Yes.
may I read it? It is in the appropriate circumstances that we have the question whether the offense under section 138 NI Act would be compounded, invoking the power under section 147 NI Act without consent of the complainant concerned is no longer integral. In short, the position is that an offense under section 138 NI Act could be compounded under section 147 thereof only with the consent of the complainant concerned. In that view of the matter, the impugned judgment of the High Court, wherein, despite the absence of the consent of the appellate complainant, compounded the offense under section 138 NI Act on the ground that the appellant was equitably compensated, could not be sustained.
So according to you, the petitioner did not receive that amount?
Not.
Not yet. Hmm. and therefore you do not know whether the fine was also directed or not. So then,
No, Your Lordship, I'll just make my submission in regard to this order, impugn order, Your Lordship. If Your Lordship will see page number 31, who had initiated the proceeding, Your Lordship.
yes,
The accused Sanish Sharma was convicted, Your Lordship, by the judgment of
Which one?
7 April
you are
2025, Your
reading
Lordship.
para?
1.
Okay,
I'm not reading, Your Lordship. I'm just apprising, Your Lordship, that the accused herein, Sanish Sharma, has approached and challenged an order convicting him and under NI Act, Your Lordship. In this appeal, Your Lordship. Now, if Your Lordship will then turn to paragraph 12 and 13, Your Lordship.
yes,
12 is where the issue of compound, his willingness to compound was discussed, Your Lordship. At paragraph 13, Your Lordship will see, on above direction, present appeal is disposed of. It is not out of place clarify that in event of failure in payment of above amount by the convict appellant within stipulated time, the Court of Judicial, a learned judicial magistrate first class shall proceed with the execution. Now the appeal has been disposed of, Your Lordship, by this impugn order, Your Lordship.
come to page 22, just once.
Page
22.
22.
The accused person shall pay rupees 5 lakhs to the complainant.
Page 21, Your Lordship.
21. It's
Ah,
22.
okay.
Order.
22.
Hmm.
Yes, Your Lordship.
Shall pay also, further, the accused person shall also pay another 5 lakhs as fine to the complainant.
Yes, this order was what I'm trying to apprise Your Lordship is that this petition itself is not maintainable per se, because Your Lordship is well aware that under inherent power, if there is no provision provided under the code, Your Lordship, then the inherent power can be invoked, Your Lordship. However, in this case, Your Lordship, he is challenging an appellant order, Your Lordship. However, the provision does not provide for that. If he is to challenge the order of an appeal, he has to approach the apex court. That's my submission with regard to the maintainability, Your Lordship. Therefore, I had come because a conviction was done by a magistrate's court, Your Lordship, under NI Act. That was appealed before the appellant court, Your Lordship. Now, the order of the appellant court has been challenged before this court under the inherent power, Your Lordship. My only submission with regard to that maintainability is that, Your Lordship. Otherwise, also, Your Lordship, if Your Lordship will see page number 32, Your Lordship, page number 32, there are two citations which has been relied at para 7 and 8, Your Lordship.
They also talk about the duly compensated. Complainant has been duly compensated. Well, in the
Yes.
present case, it appears that this has also not been fulfilled.
Now, if there is also a direction given to the executing court, Your Lordship, at paragraph 13, Your Lordship, that if there is no, if he fails to pay, then the executive magistrate shall comply, Your Lordship. Now, if there is an issue with regard to he not complying with the order or not paying, Your Lordship, the power is vested upon the executive magistrate to take an action upon it, Your Lordship.
You have to satisfy that this petition lies under inherent power. Mhm.
Well, first of all,
Okay.
the order has been asked after the prediction.
No.
The critique of the judgment is written by the. Secondly, it has technically not disposed in the family. Because it should have direct faith that we dispose with only observation. It again
Now,
says.
you see, just a minute, you see. The compound requires counsel of both the parties. This is in meters. An instrument private limited and another versus Kanchan matter. Though compounding requires consent of both parties, even in absence of such consent, the court, in the interest of justice, on being satisfied that the complainant has been duly compensated, can in its discretion, close the proceedings and discharge the accused. So he has exercised his discretion.
In this Rajniti Kalam case,
Hmm.
in this case, although the apex court has compounded the matter in the absence of the willingness of the complainant, while invoking Article 142 of the Constitution, which was not available with the appellate court below. It has got been disposal in accordance with the merit of the case. Merely
Now,
on the ground of-
according to you, it's not maintainable.
It's not maintainable. A person under the garb of inherent power cannot invoke this provision, your lordship. There has to approach the apex court. The submission being made that this is out of jurisdiction, even that has to be challenged before the apex court.
DNS. DNSS.
BNS.
DNSS. How do you satisfy that this is not maintainable?
Yes, your lordship.
Hmm.
Your lordship will see that under the provision of the code, your lordship,
Hmm.
if a person is aggrieved with the order of an appellant court, your lordship, the hierarchy goes to the apex court, your lordship, where he has to challenge the order of the appeal, your lordship. Now, as per their submission, this is not a final order, and therefore they have not come under revision, but under inherent power, invoking the inherent power, your lordship. Now, the inherent powers, the power of the inherent power is that if there is a provision under the code for the party to approach the appropriate forum, your lordship, he cannot invoke the inherent power. Inherent power is only limited to if there is no scope or if there is no provision provided under the code, your lordship. That's when the High Court can.
Can you read the provision? Can you read the provision once?
Nothing in this Sanhitan shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give to any order under this Sanhita or to prevent abuse of the process of any court or otherwise to secure the end of the justice. Yes, Your Lordship. Therefore, Your Lordship, this court has a power, unlimited power to take up issues, Your Lordship, take up the cases, Your Lordship. But the only limitation, even for the inherent power, is that if there is a provision under the code, Your Lordship, the court should not invoke the inherent power. Inherent power gives an ample power to the High Court, but it can be only be invoked when there is no provision and the party is left without any.
Where do we find that?
I'll give you I have certain citations, Your Lordship. If Your Lordship give me some time, I'll just produce before this.
You also come prepared. You're also satisfied that it is maintainable. Okay, and we'll fix it tomorrow.
Tomorrow, Your Lordship.
Okay. List it again tomorrow. Huh?
Deep review.
Yes.
Lordship, through this application, I'm seeking bail against the FI dated 11/5/2025. It has been filed against me in the removed PS case number, removed police station. May I please take a Lordship to the page number 13, that is the FIR.
Yes.
Subject complaint against.
Your name accused.
Yes, I'm Dindo Tapik. Complaint against the Dindo Tapik and others. With due respect, I'd like to inform you that, sir, when I went to drop my friend Miss Nabum in a resident of Sopor village, one person named Dindo Tapik stopped my vehicle bearing number assault is shot in his head without any valid reason. They took me into an unknown place, and that was his father-in-law, Sri Nabam Tagi's resident, and they took me for 4 hours at 12 a.m. to 4 a.m. All the family members had beaten me brutally. When got information about telephone by his elder brother, Sri Tagyo, Raju, and his family rushed to the spot and rescued him at 4 a.m. And due to his serious injury, he had been admitted at the hospital Nahalagan for treatment. This is the allegation against me also. Now, my submission in this respect, Your Lordship, is that I was nowhere at that spot. The only reason I have been named at the FIR was because
What is the offense registered against you?
it is
BNS.
it is section 126(2).
What is
It is
126?
wrongful restraint.
Wrongful restraint.
And
He was also restrained.
But the section is bailable otherwise, Your Lordship. The only section not bailable is 118, which is voluntarily causing hurt by dangerous weapon.
And what is this tree?
3 is common intention, Your Lordship.
Okay, there were more than one person.
Yes.
Okay. You can call for a scan copy.
Yes, Your
Your
Lordship.
Lordship, kindly see my reason. My main reason here is that I have my exam, Your Lordship. I'm a third-year student of continuing my LLB student. My final exam is supposed to begin from 9th of the next month. Only more than 2 weeks left for my final exam.
Mr.
Ketaja.
Ketaja, non counsel for the petition. Start. I've also heard Ms. Chini, non additional PP for this stage start. This is an application filed under section 482 of the Bharatiya Nagrik Suraksha Sanhita 2023. Frame for grant of anticipatory pre-arrest bail, apprehending his arrest in connection with Doimo PS case number 60/2025 under section 126(2)/118(2)/3 (5) BNS 2023 start. The case of the petitioner is that on 11/5/2025, once Ritagio Raja lodged a written complaint against the accused applicant, inter alia alleging therein that when he went to drop one Miss Enoku to her resident at Sapo village, the accused applicant stopped his vehicle and assaulted him with sword on his head without any valid reason. What is this? It's difficult to understand. Huh?
Your Lordship, the type copy is at page number 13.
Okay. So this kept for 4 hours to whom?
The complainant, Tagir Raja says that he has been kept.
Okay, to the complainant without any valid ground, and they took her into unknown place that was his father-in-law's so and so resident, and they kept for 4 hours. No, kept the lady, not to him, it appears.
Yes, the lady, Your Lordship. Kept the lady for,
Lady seems to be the wife of the again accused.
there is no reference to that because it says took her into unknown
Who
place.
is
That
who
was
here? Who is who
his
here?
father-in-law.
Whose father-in-law? The lady is whose wife?
The lady is my wife, but we don't stay together, you must. It's Nabong Opu, which has been mentioned in the
See,
FIR.
lady is his wife, not the wife of the informant.
That is my wife. And that is the only reason I have been mentioned in the FIR.
Because the father-in-law mentioned him, here is someone Nabam Tagi, Your Lordship, which
Yes.
is also not, whose father is that, we are not, whose father-in-law is he, that is also not clear.
The mix-up has lodged complaint on behalf of the wife of the informant also.
No, it seems the informant has also been assaulted.
Informant has also been assaulted.
Yes.
And according to him, the lady
The lady
has also
was-
been kept in his father-in-law's house.
Yes. In
So that
in
cannot be
father-in-law
confined.
of Dindo, the accused
That
maybe.
probably cannot be the wrongful
Mm.
confinement. Difficult. And who was rescued? Hmm? Who was rescued? And then the boy was rescued again.
It seems,
It's-
if I understand the FIR, Your Lordship, their vehicles were stopped. He was assaulted. The girl was taken to the
Father-in-law.
father-in-law's house and kept her.
Father-in-law's house means the house of the accused.
The high, not the house. That's what the even the name is different, Your Lordship. Whose father-in-law exactly is not this.
Anyway, so he was assaulted, huh? And based on the above written complaint, the case was registered being doing PS case number 60/2025 under section 126(2) and 18(2)(3)(5) BNS. The land counsel for a petition or some that the accused is innocent of the allegation made in the above FIR. However, since he is a name accused, and where have you stated that you apprehend your arrest? Have the police acted upon the complaint, done something to
No,
arrest you? Where have you stated?
There are two.
Para?
Two.
This is only allegation.
The para of the top party. As he filed this anticipatory bail, as he is planning arrest.
Para 2.
Yes, yes.
Where?
that the alleged accused Indo Tafik has filed this anticipatory bail as he is apprehending arrest in connection with the most case number.
Since he is a named accused, the accused apprehend his arrest in connection with the above PS case. Stop. Hence this application claim for granting pre-arrest bail. Stop. Call for the scanned copy of the case diary. List this matter again on
On 22, Your Lordship.
22.
Because I have exam, kindly please grant me interim for protection. Because my exam is here to
22 would be
22 is Wednesday, Your Lordship,
Wednesday.
or Thursday.
Let us do next week.
26.
When is your exam, you say?
It is from 9th.
Next month, Your
Next
Lordship.
9th. So if I'm arrested, you know how I'll prepare for my exam.
Therefore, I was taking a very short date, Your Lordship. If on 22, we can dispose of the matter.
Okay, 22,
otherwise,
22,
yes.
okay,
Because
22,
kindly
22.
procedure.
Fair. In the meantime, in the interim, it is provided that in the event of the accused applicant is arrested in connection with the above PS case. PS, right, the PS case. Come, he shall be released on interim anticipatory bail on execution of a bail bond of rupees 15,000 with one surety of like amount to the satisfaction of the arresting authority with further condition that he will appear before the he will cooperate and appear before the eye of the case as in when called for, and he shall not where is CRPC? Directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such fact to the court or to any police officer. List is matter again also and so on. 22, you said 22.
22, Your
Okay.
Deep breath. 22. Exam.
Thank you, ma'am.
I note it is an application under section 482 of CRPC 973 and corresponding with the section 528 BNSS 2023, referring for prosecuted by the date registered as PS case number 03/2021.
Is it a joint petition?
Yes, joint, yes.
Okay, what, let us see the FIR. What is the allegation? Otherwise, is it against
This is FI. My lord, this is FR. First FR, annexure A.
first FIR? How many FIR are there? How many FIR are there?
The victim filed a fire on
The main allegation.
27 December 2022, 20. And on 27, the senior citizen of the particular villager and ground write a letter to the PS not to register the case, and they will settle the matter in the village level.
Just a minute, this page 17 is the first FIR.
Especially the FIR. The page 18
Is
is,
there
18 is a withdrawal intervention of senior citizen of the particular village and panchayat.
okay. The same person has written this,
then
just a
again,
minute, just a minute. The FIR was lodged by one N. Sarah.
yes,
So
Sarah.
this withdrawal petition was filed by whom? The same person.
Same person.
Where do we find his name in the withdrawal application?
We on it, page 20, Annex C.
Page 20. No, your withdrawal petition is page 19
Withdrawal petition is page 19 and 20.
or 19 and 20. 20 is the handwritten one.
Page 18 and 19 is
Just a minute.
the application
I'm sorry.
from the
Yes.
senior citizen.
Who appears? Mr. Tado? So, what do you say? You want, the record is necessary? Here in this case?
My lord,
What is the punishment? What is the offense? Let us see the offense registered against you. 325. The case of which year? 2020.
21, old case.
This was in, it appears that this was during the Panchayat election. Whether the record is necessary or can it dispose of? Can it be disposed of?
Your Honor, the party, we have settled the above differences on last year, that is. Please, my lord, please.
What is the status of the trial? Case has been charge sheeted.
Yes, under evidence stage.
Evidence stage.
Yeah.
Okay.
On, it was.
Okay. You
Both
have
parties
also
settled.
annexed statement also. What is this? Deposition or this is the police statement? What you have annexed?
My lord, please, please,
This is police statement, it appears.
There's a charge sheet, yeah, my lord, all are charge sheet.
Okay, charge sheet. Then if it is in evidence stage, have you also annexed the evidence of the prosecution witnesses?
Yes,
Where? How many witnesses have been examined?
3 or 4.
Okay, have you annexed all those? Have you annexed the evidence of all those witnesses who has been examined?
3 or 4 has been done, I think.
Have you annexed those
I
and
did
their
not annex.
deposition, their evidence? Have you annexed?
I don't know.
So
Call for the record, man.
record need to be called. for.
PCR, yes.
I thought he has not annexed it. Okay. Hard, Mr. You are Mr. Teacher. Land counsel for the petitioner. Also hard, Mr. Genie. Oh, sorry. Land additional PP for the state staff. This is an application filed under section 482 of the, this is under CRPC. Okay, 528. BNSS 2023,
Yes,
praying for quashing of the, where have you mentioned, okay, GR case number 56/2021. arising out of Sagali PS case number 03/2021 under section 457, 325, 427, 34 IPC pending before the Court of Chief Judicial Magistrate UPA. Call for the scanned copy of the trial court report. List this matter again after a week.
After a week, man.
After a week. So,
My lord. My lord, please. Please. Next tomorrow. 22 is again someone issued on 22 this month. So I might pray that they may be stay for the proceeding.
Where have you stated?
Because we.
Where have you stated the fixed for 22? 22 is fixed for what? 22 is fixed for what? On 22?
Evidence.
Evidence of?
Someone is issuing continue.
You have not annexed the evidence also to peruse. For perusal. Okay.
Your Honor, this accused
Which I think
victims are
the para proceeding can be stayed here.
Yes, Your Lordship, till the return evidence, the further proceeding may be stayed, Your Lordship. Since they have entered into settlement and only one section is, my lord, non-compoundable.
Yes, the further proceeding of the GR case number 56, 21. They are pending before the CJN shall remain stayed till the next returnable date. Okay.
Obliged, Your Lordship.
May I please your lordship? Lordship, yeah, similar case, lordship, arising out of same FIR and the charge sheet, and then the case that has been pending before this before the landed court below.
Which case?
This case, lordship.
Similar to the previous case?
No.
Hmm.
I'm talking about one case that is pending before the landed district and sessions court, PCA court. That has been stayed, lordship, arising out of the same FIR charge sheet.
Stayed by this court.
This honorable court.
Okay.
Lordship, issue in nutshell is, lordship, the petitioner, while he was working as an administrator.
This SIC case?
SIC case, lordship.
Yes. What is the allegation? Yes.
Lordship, allegation is that, lordship, well, when I was working as an administrator of Arunachal Pradesh Consumer Cooperative Federation, I have acting as an administrator, lordship. I have taken a loan of 5 crore, lordship, from Apex Banks, Arunachal Pradesh State Cooperative Apex Bank Limited, lordship. Now that as a credit case, 5 crore in the year 2013, lordship. Now that 5 crore was money that was taken as a loan.
5 crore
from FX Bank, lordship.
FX Bank.
FX Bank, lordship. Now that loan was utilized in terms for payment of HTS bills, lordship, were engaged for the PDS carriage. Those contractors who were engaged in carrying PDS items, lordship. That 5 crore was paid to those contractors, lordship. In fact, three contractors were engaged, and the entire 5 crore was paid to those contractors, lordship. Now the case is, lordship, the entire amount, the 5 crore that has been alleged to have been misappropriated, has in fact been paid back by the Cooperative Federation, lordship. Well, I was working as an administrator at that point of time, lordship. Lordship, may kindly come to page number 45 of my petition, Lordship.
Yes.
This is a certificate, Lordship, from the branch manager, Cooperative FX Bank Limited, Lordship. The loan that was taken from the bank. So it's read, Lordship, this is to certify the case credit loan account number so and so maintained by the Arunachal Pradesh Consumer Cooperative Federation Limited has been cleared and recovered 5 crore and 10 lakhs with interest and close settled on so and
This
so.
is in respect of whose case? Your case?
Yes, my case. In terms of this particular clearance, Lordship, there is no case at all against me, Lordship. But
So the it was cleared and recovered.
This is something which my lord, as my lord has pointed out, my lord. I'm not aware, my lord, whether this amount which they're showing, my lord, whether it is connected with this particular case or not.
Okay. Now, what is your submission?
My lord, you kindly come to page. My lord, in fact, my lord, here there were 2 FIRs, my lord.
Okay.
But upon an order from this honorable court, my lord, those 2 FIRs were amalgamated, my lord, and thereafter the charge sheet was filed, my lord. Now the case
The case has already been charge sheeted.
Yes, my lord. And
Trial, what is the status of trial?
well, there are 2 accused, my lord.
Mhm.
The one, for one accused, it has been stayed by this honorable court, and the other accused, he has
In the
filed
same case, same FIR.
same FIR.
same. No, different FIR, but amalgamated.
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 Okay,
But-
different allegation must be different.
Yes,
In both, of course, with the same.
the
act.
degree of allegation is different, my lord.
Uh-huh.
In fact,
In first FIR, Lordship, the allegation is in regards to the accused number 1 is he was acting as the administrator of FX Bank, who has granted the loan, who was given the loan. I was the one who has taken the loan, and another allegation is against
The first.
the person who has given the loan.
Where the interim is granted,
He
is the person who is administrator.
is the administrator of FX Bank,
Apex
Okay,
Bank.
you're the person who took loan.
who has given the loan,
No, he was the one who has given the loan, and he is the one who has taken.
who has
Taken the
taken the
loan.
loan.
But
Yes.
the allegation here is that the administrator of the Apex Bank, in connivance with the Consumer Federation, they have misappropriated the total amount of 5 crores, my lord. But during the course of investigation, my lord, if my lord turns to page 87, my lord. Now, this interim order was only passed only on the basis of these documents, my lord.
87.
87, my lord.
What is this document?
87, my lord, we find that it is the minutes of the advisory committee meeting of the AP State Cooperative FX Bank. Now, the allegation was that he has not taken the consent of the NABARD and
Who has not taken consent of?
the administrator of the FX Bank.
Administrator.
Yes, because he was in connivance with the administrator of the Consumer Federation, my lord. Now, next page, my lord. Page 88, my lord. Dr. Oleg Taring, APCS, Administrator
88.
88, my lord.
Yes.
This is the minute of the advisory board, my lord.
Mhm.
Now, my lord will find the attendees, my lord.
Just a minute. This is minus.
Yes, my lord. My lord.
38 and so. And accused in the administrator is.
One,
Oh,
serial number 1 is the accused, my lord,
okay.
of the bank, my lord. And 2 is the general manager NABARD.
He's
3,
also
rural development.
accused.
No, they are not accused, my lord. There are
Okay.
only 2 persons, my lord. But from this document, my lord, we could find during the course of
Now,
investigation.
whether the name of the present applicant is there?
No, my lord, no, my lord.
Okay.
And the next page,
No,
my
no,
lord,
What,
the
by,
serial-
by this minute, what decision was taken? What do you want to show from here?
next page, my lord, serial number 12, my lord,
Hmm,
agenda 12.
yes.
Now, this is the CC payment which has done, my lord. To consider the CC loan proposed of APCCF Limited for buffer stocking. Now, this is the loan we are talking about, my lord. Now, since there was an allegation that the administrator of the Apex Bank, in connivance with the administrator of the Consumer Federation, has misappropriated, my lord. And this decision was taken without the consent of the NAVARD and the concerned bank officials of the bank, my lord. But
No, this present decision,
yes, my lord.
the,
But then this document shows, my lord, that in the meeting, NAVARD was present, the Apex Bank was present, and it was a consent decision, my lord. Only basing on this document, my lord, the interim order was passed, my lord.
this was when, this was. This was 2013.
My lord.
Okay, so,
But in regard to the present petitioner, my lord,
hmm,
now the allegation is that, my lord, there is no doubt that, my lord, he has not received the loan, my lord. It is on record that he has received the loan. But those amounts were transferred into his wife's account, my lord.
okay,
There is the allegation.
the amount,
The loan amount.
he is, what he is, otherwise,
Because he was the administrator of the Consumer Federation, my lord.
okay, consumer.
Yes. The Consumer Federation has taken the loan, CC loan,
But,
from the Apex Bank, my lord.
hmm, kept in the wife's.
Yes. And both the administrators were made the accused, my lord. But the degree of allegation is different, my lord.
Now, since, when this was granted recently, you have idea what is the status of the trial, status of the trial of the case?
No problem.
Hmm?
No, that particular order, my lord,
Hmm.
in fact,
Entire, by this order stayed.
Entire proceeding has been stated.
I don't
entire
think
proceeding.
and that should have been in state, my lord, because it ought to have been for a particular. petition,
Uh,
No,
my
this
lord.
is stay in respect of the present petition only, not the entire.
Lordship, it talks about entire, I may read out the line.
Where?
Order. Considering the last paragraph.
Okay,
Considering the submissions of the land council for both sides and also considering the entire facts and circumstances of this case on perusal of the charge sheet and relevant materials available on record, I find it fit case to pass an order of stay till returnable date. Accordingly, it is provided further that proceeding in PCA number so and so arising out of so and so pending before the Court of London PCA Act UPS shall remain state suspended till returnable date.
no, the prayer itself was for stay of, in respect of the applicant appears.
Yes, my lord.
Now, what do you want? That the entire, if the proceeding has already been stayed, then what more you want?
Notice may be issued and records may be called for lordship. And since
your prayer is for?
since the matter is one of the same thing,
Your
lordship,
prayer is for? Question.
lordship quashing, lordship.
Notice can be issued then.
Yes, my lord.
Notice can be issued.
And this matter may be, my lord, club with the
Hmm.
earlier petition, my lord.
Mr. J. Jini, Land Council for the petitioner. I have also heard Mr. Opada. Mr. Opada, you are here as a special, oh, sorry, SIC, huh?
No, my
Standing
lord,
Council
it's
SIC.
ACB now, my lord.
Oh,
ACB,
ACB means,
Anti-Corruption Bureau.
oh, not SIC, no?
Not
Okay,
SIC.
Standing Council, ACB, you have to change it. Anti- Hmm. This is an application filed under section 528 of BNSS 2023. 528, huh? Seeking quashing of FIR number 09/2016, dated 29/2016. Within bracket is amalgamated with FIR number 11/2018, dated 19/12/2014. Bracket close. Registered at police station SIC Vigilance, Itanagar, Papumpare district. The consequential charge sheet number 01/2024, dated 8/5/2024. What is this order? 29/1/2025. The order dated 29/1/2025. What is this order? Passed by the censors.
Lordship, this is the
Where the charge have been, okay,
charge has been filled.
okay. Whereby charge has been framed against the accused petitioner under section 120B 409 420 of the IPC, Indian Penal Code 1860, read with section 13 within bracket 2 of the Prevention of Corruption Act 1988. Start. You have not mentioned the case number of go on.
Case number is PCA
Where,
5/2020.
where do we find?
Lordship, in the first course title, Lordship.
PCSIC. PSSIC business and section.
PCA case number 5/22.
5 is at
PCA number 5/2020.
PCA number 5. Okay.
Yeah, Lordship.
Hmm. Under section okay. That one. Order 29, huh? Whereby charge frame in PCA number 05, huh? 2024. Okay. Correct. Who else is the party? Only the state. Okay. Issue notice. Since Mr. Opada accepted notice, no formal notice need be issued. Staff call for the scanned copy of the trial court record. Staff. When this matter is fixed, this matter along with the,
No date is fixed, Lordship.
okay, along with the criminal petition. This matter after 4 weeks,
Madam.
along with the criminal petition number 44/2025. Okay.
Obliged.
Yes.
My lord, may I? My lord, this is a joint petition under section 582 of BNSA. This is your, my lord.
This is question petition.
Yes, this is very old case, 1998 case.
1998.
1998 case. The FIR is, Your Honor, in
What is
Uh,
the, what is the allegation?
Allegation is, my lord, that the accused petitioner has this stolen 3 bundles of iron rod
Okay. So
from the compound of the
charge sheet filed?
file.
What is the status of the case before the trial court? Which court?
Yes, it's in a prosecution witness stage. The charge was framed, Your Honor.
Which court? Before which court?
Before the learned judicial magistrate first class,
UPI.
UPI.
Okay. Charge already framed.
Yes, we are here, Your Honor. During when it was charge sheeted, it was of section 279, 447, and 34 of IPC. But later, during the consideration of charges, since the theft was committed inside the compound of the government quarter, so it was altered to theft inside the dwelling house for 380. So that is non-compoundable. Your Honor. That is the case. And Your Honor, charge sheet is here. Charge sheet.
Whether,
Charge sheet order copy.
just a minute, huh?
120.
Whether the aggrieved,
120.
is the government is, or government is also aggrieved?
No, no. It's
Okay.
a private.
Okay. Yes, Mr. Tata. Case of which year you said?
1998. It's very old case. And
98.
other few named accused also expired, Your Honor.
Okay.
Theft was committed from government premises,
This
from
quarter only.
government quarters compound. And this construction road is made for government construction purpose.
Okay, what was the material?
Material was iron rod.
Okay, construction material
Yes.
belongs to government.
No.
Yes. Yes. It
If
is-
it belongs to government, then it will be difficult. You have to, it will be difficult then
No,
in that case.
no, my lord.
If it is a private, otherwise,
No, what-
whole case. And then trial, just charge only framed.
Yeah.
Now after 28 years.
Yes. My lord, may I read the FI,
Yes.
page 23. Type
Now-
copy.
Now, since FIR may not concern, but then since the charge sheet file, we need to go through. Then, okay, we'll call for the record, huh? Reference to some, yes,
Yes, may I?
yes. Compound.
With reference to the cited subject above, I beg to inform you that today on 2-3 hours to 30 hours, some group of 5-6 people enter into the compound of my golf quarter.
Okay, his house construction, his own house construction.
Yes, no, not the government.
Sorry, I misread.
You say that it was from the government quarter.
Yes, government quarter for
I misread. I apologize.
personal construction.
Otherwise, all admitted that they have stolen.
Let me check. Okay. Anyway, we'll call for the record then.
Yes.
380 is, yes, 380 is not comfortable.
We'll call for record.
Yes, it's not.
Mr.
My lord, in that case, entry may be
You are Mr.
J may be.
J maybe.
Yes.
Learned counsel for the petitioner. I've also heard Mr. Taro. G Taro, learned additional PP, stop there. This is an application filed under section 528 of BNSS 2023 for seeking quashing of the criminal trial proceeding. Quashing of where is the case number?
My
Where
lord.
have you mentioned the GR number?
Yes, yes. GR 130
Quashing
98.
of the GR number 130
98.
98 under section 98 arising out of PITA PS case number 7298 under section 380 448 34 IPC. Pending before the court of the Chief Judicial Magistrate, UPR. Issue notice, call for the scanned copy of the trial court record, staff. Since Mr. Taro has accepted notice on behalf of the state respondent, no formal notice need be issued. Okay. Who are the accused and who are this,
My lord,
the informant here?
informant.
Informant only one.
Yes.
Okay, rest are accused.
Yes.
Okay, fair enough. Considering, considering the contention made in the petition and upon hearing the counsel for the petitioner, it is provided that the further proceeding of the GR case number. Where is the GR case number?
Yeah, case number even mentioned in the post title. 130.
GR case number 130/98 under section 380, 448, 34 IPC pending before the Court of Chief Judicial Magistrate shall remain stayed till the next returnable date. So, list is after when? After 2 weeks?
Yes.
Okay.
Actually, your lordship, in this case, construction material was for construction of government quarter for the complainant.
Government quarter for the
Complainant.
complainant.
Complainant is
And then the
an
material
employee.
belongs to the government
Yes, indirectly or directly. And this CS
in
is
the
not,
charges.
is not
In any case, since we are
legible.
recording the record,
Yes.
we'll see the record. Okay. Yes.
My lord, may I? But this is a very simple case, my lord. What happened, my lord? I purchased a land, my lord,
Just a
from,
minute, this is here. Affidavit in reply also filed.
yes.
Can it be listed for hearing? It's ready for hearing, it appears.
Yes.
Hmm?
Yes.
Mr. Chairman. Okay, you may have been the picture, Land Council for the petitioner. Also had Mr. T. Jammu, Land Council appearing on behalf of the respondent staff.
1, 2, 3, man.
Hmm?
Respondent 1, 2, 3, man.
1, 2,
1, 2, 3.
1, 2, and 3. Staff. Whether the record was called for?
No, my lord.
Hmm?
No, my lord. So what happened, my lord? This issue is very simple, my lord. One Kaba was held, my lord. One Kaba was held, my lord. Now, subsequently, another Kaba was also held. It was in my favor.
Record not required.
Not regarded. Two Kaba was held. It was in my favor, my lord. Now, what happened against the second Kaba? They have prepared appeal, which is still pending, my lord.
Where?
Now,
Appeal is pending where, which, before which?
before the ADC, my lord, which they are not pursuing. Actually, it should be before the court, my lord. It was transferred.
The first Kaba was in your favor.
Yes, sir.
Second Kaba?
Kaba also in my favor. Now, against the second Kaba, they have prepared appeal, my lord.
Okay.
And that it is also still pending, my lord.
Hmm.
Now, subsequently, what happened, which they could not do directly, they have done it indirectly. Now, they have also held third Kaba, my lord, behind our back, without making us as a party, my lord.
They have also?
Held third Kaba, my lord. Third
Okay.
Kaba for the same
Third
issue.
Kaba was conducted based on what?
Same
New-
issue.
New complaint?
Same area, my lord.
The area, okay, but the new complaint, fresh complaint was lodged?
By from the person from whom I have purchased the land, and then by the son of the respondent number 1, my lord, who is respondent number 3.
Anyway, since we are fixing it for hearing,
My
we'll
lord.
have hearing on the matter
My lord.
in detail.
It may be
Okay.
admitted.
Since the
my lord.
parties are represented and affidavit has been exchanged, let the matter be listed for hearing.
It may be admitted, my lord.
Not yet admitted.
Not
Okay,
yet admitted.
Admit, the appeal is admitted. List is for hearing after
After
2 weeks.
2 weeks, my lord.
Okay.
Obliged.
Please, Your Lordship.
Yes.
My lord, though I have taken steps upon the respondents 1 and 2, they have not appeared before this honorable court. So the order was passed that the matter be listed for admission. Issue is regarding lordship.
This reveals the service is complete otherwise,
Yes,
but then they are not yet appeared.
yes.
No
Oh,
wakalat nama, nothing, never
No.
appeared.
No,
till
no,
date.
they never
So what
appeared.
do we do?
Lordship, there is already an order that since the steps have been completed, matter may be listed for hearing, for admission hearing. The second last previous order.
Admission. Now, since the parties are not appearing, what do we do?
Lordship may take up the matter. Since this is the third time that they are not appearing. No, so notice has already been served upon them. Lordship may today otherwise admit the matter and list it for hearing next week.
What is the matter, this matter about otherwise?
Matter is very simple, Lordship. There was a Kaba decision in my favor.
Okay.
For that, I had filed an execution case. Then the concerned court, the ESC Assistant Commissioner is Ruxin, has refused to execute the Kabang order, saying that there is a subsequent Kabang order, which is known as because there cannot be a re-Kabang. There cannot be a second.
Whether the subsequent Kaba they are decided in whose favor?
Decided in the favor of the respondents. Respondents.
Okay.
That I was not actually aware of. But the assistant commissioner.
Whether the earlier Kaba has also been made a mention about the earlier Kaba in the state impugn.
No
Have you
mention
that-
has been
have
made.
you
No,
included
sir.
that order?
And that what they ought to have done if they were aggrieved by the first Kabang, then they could not have conducted a second Kabang. They could have filed an appeal, which
Yes.
was not
No,
filed.
well, whether you have challenged the second Kaba order.
Lordship, that is known as I need not challenge that, Lordship.
No, why you did not challenge?
Lordship, that Kabang, second Kabang, first of all, I was not aware.
Now, supposing if they comes for execution, then
Yes,
now, unless you challenge it, and
Yes.
unless it is set aside and quashed, and it
yes.
will be executed in against you only. That you required to challenge that order, the second Kaba, because it was already decided, or not to have decided.
Yes.
You could challenge.
Lordship,
Could
they have not also filed appeal against the first Kabang. They could have filed if they were agreed.
But then you say subsequently they have decided, as you said,
Yes.
and this Kaba
Subsequently,
second decision-
subsequently meaning when I had filed an execution petition,
Hmm.
then only I came to know. I was not a part of that Kabang. I have no knowledge about
Now
that.
you see, the person who decided the second Kaba
Yes.
is also a government authority only, isn't it?
Not government authority, village authorities.
Village authority.
Village authorities. Also, it has been
Now,
presided.
whether before or after, whether
Yeah.
it was a notice was given to you
No. I was not part of that
after
Kabang.
after decision,
No. No
they
notice
did not do
whatsoever.
anything.
No.
Person to the decision, second Kaba.
No.
Okay, that means you think that you are not, since you are not being affected.
I was not even a
not
party in that.
required to challenge.
Yes. I was not even made a part. I was not called.
Supposing, what I'm saying is, supposing, since it was decided by the same GBs, village authority.
Not by village
Customary-
authority, by
Same authority
it
or
was
different?
no, different. It was presided over by a political interpreter, which this honorable court has already held, that a political interpreter, the PI, has no power whatsoever.
There is whatever may be,
Yes.
whatsoever may be, but then
Yes.
since it was decided by the political PI
Yes.
or the GB, whosoever may be, but then
Yes.
if it affects you, probably because you are the decision or the
Yes.
Kaba decision is already in your favor.
I-
Could have challenged. You could have challenged.
Since Lordship, I did not have
Hmm.
any knowledge about that Kaba,
Okay.
that second Kaba.
Have you mentioned here in your
Yes,
petition?
this is also, I have also challenged that Kaba.
that second Kaba,
Okay, here. Okay.
by way of
That is what I'm
distribution.
saying.
Yes,
Okay, then in that case, no problem. Then,
not as an appeal, but here, saying that there is a total lack of jurisdiction.
okay, so now, by filing this, what you have challenged then?
First of all, that second Kaba. Secondly, for a direction to the Assistant Commissioner to dispose of my execution petition.
So they are not doing anything?
No.
When it was filed?
Execution petition was filed.
Any notice was issued to the respondent?
Yes, Lordship.
Thereafter, what happened?
They have, that was
what is
in
the latest
April
state?
2023.
23. What is the
2000.
status? What is the status of this execution petition?
It is
Lying there.
yes,
Have you
just
made
lying
an
there.
application before the execution court?
Lordship?
Have you made an application?
Yes,
before-
application is at page 59. Sorry, page 37. Page 37. Page 59 is their objection also.
59 is?
Their objection,
Okay. They have
the respondent's objection.
Okay.
Execution petition is at page 37.
Okay. What is, and which one is the last or the agreed by you?
Lordship,
You are agreed by which?
Lordship,
Last for the-
impugned order is at page 81.
By this or the what the?
Lordship may see
Hmm.
third last paragraph of this page 81. On perusal of the records, it is seen in compliance of the Kabang order dated 1/3/2011 that the judgment order has deposited a decreed amount of rupees 35,000 only in the office of the circle officer Chile Oyan, and the circle officer issued notice to the decree holder to collect the decreed amount. It is seen from the records that the Kabang decision dated 1/3/2011 is already under execution, and under this circumstance, this court finds no ground to interfere. Hence, assistance sought for execution of Kabang decision dated 21/2011
declined.
is declined.
So according to you, what is to be executed then?
Lordship,
This, according to him.
according
to this
to
order,
according to
already
me,
complied.
Lordship,
Hmm.
what happened is, Lordship,
Hmm.
in the first Kabang, they were to pay me certain amount or else return the land,
Hmm.
Lordship. Now, there was a dispute over the amount and that it was not paid. Later on, they started disturbing, Lordship. Lordship may see, kindly see page 37. This is my execution petition. Page 40, 39 and 40, Lordship, is the mode of assistance sought. They had actually, they were supposed to, Lordship, give me back the land, and then if they wanted to take, they were supposed to pay me some amount. Now I had taken over that land, I was staying there. They started disturbing me without paying any amount, and there was a dispute about the amount. So since they have not paid, it was in my name. Now thereafter, it seems behind my back, there was a second Kaba saying that the amount would be reduced to some 35,000, which I have no idea about. The second
Okay,
one.
this 35,000, what he's talking about?
Yes.
The order.
Yes.
Is in the second Kaba.
Yes.
Not in the first Kaba.
Not in
So
the
they
first.
have linked it.
Yes. That is why, Lordship. Lordship, otherwise, matter may be listed for hearing next week. Maybe they will come.
On perusal. Your first Kaba was on which date you said? 2011?
Yes,
And second Kaba-
21,
second Kaba
2011.
was?
Second Kaba is at
1/3?
1/3/2011.
Immediately,
Not immediately, after almost after 2 months.
2011,
2011.
long back.
Yes. Lordship, I filed the execution petition only because after so many years, they had started disturbing my possession over the land. Otherwise, it was in my peaceful position.
Now, since if it is under your peaceful possession and the Kaba also decided in your favor,
Yes.
could have lodged FIR instead of, because was it required to be executed because it is already under your possession only.
They started disturbing my
No,
possession.
that is why FIR,
Yes.
FIR could have been the right.
FIR also, Lordship,
Okay.
page 35.
35.
Yes.
What did they do pursuant to the FIR?
They did nothing, Lordship.
That could have been pursued. Because
No,
execution,
instead, no, Lordship,
how this will be executed according to you? Because
Lordship.
it is under your possession.
Yes.
Only they are disturbing,
Yes.
which is criminal act.
Yes.
How this can be?
No, Lordship, sorry, Lordship. They were disturbing my land, and instead they file FIR against me, saying that I have criminally trespassed. This is at page 35.
But still under your possession only.
Yes, it is under my possession, but they were disturbing. Because there was no Lordship execution for formally, Lordship, restraining them from the land, Lordship. There was no such formal order.
Let us see your prayer in the execution. What is your prayer?
Lordship, I have already read out.
Prayer.
Lordship, the mode of execution preferred. That is page 39 to 40, Lordship.
Restraining.
Yes.
You need one formal order restraining them.
Yes. Also to remove them and their agents. They have forcefully disturbed my position. Instead of when I objected, they instead filed an FIR against me.
No, you say that it's order 1/3/2011 was passed by circle officer. Your prayer, you see, not by GB.
Lordship, which side, Lordship?
Para. No, the page 15, your prayer.
Lordship, it was under the supervision of the PI, Lordship.
Supervision, no.
Yes.
You said if you order passed by circle officer, you said. Where is this order?
1/3/2011 is at page 82.
80?
82.
Have a typed copy also.
Yes.
This order was passed by CO.
Lordship, it was under the dictation of the
Yes,
CO,
to
but it
CO.
was by the PI. Lordship may see the signature. Signature is at page 83.
No,
Ojing Dai PI, CO's office. Page 83.
passed by.
Yes.
But your prayer say you say that it's order passed by CO.
It was under the office of the CO, Lordship.
Where is the,
Lordship, page 83. The signature, Lordship.
no, this is, where is the translated copy?
Translated copies at page 86.
Who is this tag time?
Lordship,
Tag Tasing is the respondent or
the petitioner.
tag Tasing? But the decision decided that the disputed land will be remain and be retained to Jamo family. Who Jamo family is the respondent?
Yes.
So the decision is so earlier amount, how much amount?
51,250.
So that is, has been reduced to 35.
Yes, reduced to 35. Also, as per the decision, I was to retain the land.
No,
Oh, Lordship, the Jamo family could retain the land.
Jamo family, not
yes,
you, not
could
you.
retain the land only on the payment of this amount of money, which was not paid, and it seems an appeal was made to the circle officer, which is not the authority to file appeal. The appeal itself was, and in that Lordship, there was another Kaba, second Kaba, this one.
Now, on payment of this 35,000, the land was to be retained by Jamo family only,
Yes,
not by.
it was also Lordship.
Where is the first Kaba?
That is page 18, Lordship.
80.
18, 18.
18.
page 18, but since this is an Adi, the
Translation?
translated copy is at page 25. In terms of this, per pura, they were supposed to pay 25,000, and on calculation of the measurement, it amounts to rupees 51,250. The measurement is in the next page.
Just a minute. No dispute. The way from this in the
Then Lordship, thereafter Lordship, what happened is, this is the Kabang dated 21/1
no,
2000.
just a minute. Huh?
Yes,
This according to you, this Kaba decision at page 25
Yes.
in your favor.
yes,
But then here also you see on payment of this amount,
yes.
it has to go to the Jamo family.
No, no, no. If the Jamo, the Lordship may see the point 4. The plot of land on the right side of PWD road has to be purchased by Jamo family. Purchase that is from me. They have to give me money. Then only the land will be
So they
reverted
did
to
not
them.
give you the money.
Yes. Then it was also decided that the amount to be paid would be 25,000 per pura. Now, the land was measured by the next page, and as per the rate given, the amount, it amounted to rupees 51,250.
51.
Yes,
Okay, this
51,250.
is the amount.
Yeah,
Okay.
yes, according to the measurement,
that is-
because that was more than 1 pura, 2 biga and 53 lusa,
Okay.
according to their measurement, Lordship. Now thereafter, since that was not paid, there was another decision, a continuation of this, page 31, Lordship. This is 24 to 2011. Lordship may see page 31 is the English translation. On dated 21 2011, Sri Tabiram Jamo, Yameng Jamo had a kabang with Taek Singh and Taek Singh senior and junior. All the parties bring from Sika Tode in regards to the plot of dispute of land between. In the kabang held on 21 2011, it was decided by the GBs and the House present that the disputed land belongs to both Sri Junior, senior and junior. It was not decided Jamo family had to purchase from them rupees 25,000 per pura. That was in the kabang. The disputed area was measured on 22/1/2011 by the GB secretary and other villagers. The land of both Taek Singh senior and junior was measured, and it was 1 pura 53 lusa. The plot of land of Taek Singh junior had an area of 2 puras and 70 lusa. After completing all the measurement, the Jamo family were told to buy the disputed land, but the Jamo family did not buy the disputed land within the time period of 1 month. Therefore, the GB of Sika Tode village and secretary had decided Taek Singh and senior junior shall possess their plot of land as marked by the kabang dated 21/1/2011.
Okay, this is okay.
Yes.
So after this,
After this,
then
there was no.
this comes 86.
Yes. After this comes that Lordship 1st March 2011, which your Lordship has seen at page 86.
So what we'll do, admit it and fix it for hearing.
Lordship, since they are now.
So then for end of justice, you
Yeah.
take one more steps.
Lordship,
we
it
are-
has already been served to them. We have
That's
served
there.
personally, and we have filed an affidavit to the effect.
Okay,
It is not just by post, Lordship.
Dusty by Dusty.
Yes, Dusty, and we have filed affidavit also.
Okay,
So, Lordship, since the matter since there is a lot of disturbance of peace in this regarding the because they're from the same village. So therefore, this needs an early disposal. Lordship, can it be taken up next week for hearing?
Just a minute, your prayer probably.
Yes, my prayer is first of all,
No,
quashing of that second
No, no.
Kabang decision.
This, you have mentioned it's the order passed by the circle officer. Probably this need to be corrected. Not by circle officer, but circle office
Under the direction of the circle officer.
under the direction of the circle
Yes.
officer. Not order passed by the circle officer.
Yes.
Otherwise, this,
Yes,
if we
Lordship.
direct the circle officer, it will be difficult. It's
Yes,
PI.
yes. If your Lordship allows, I will correct this page.
Better correct it.
Yes. And maybe allowed and in the and Lordship, since this requires urgent hearing, may be taken up next week.
Okay. Yes, hard this and done counsel for the petition. None appears on behalf of the respondent. Despite of receipt of the sum. The notice, notice, start. There are two respondents.
Yes,
Who is the other one?
they're from the same family.
Okay, the family itself claims.
Yes, this these are the dispute was between Taek Tasing Senior and Taek Tasing Junior and these two persons.
Okay. On 21/2/2025, this court observed that this court, while observing that the notice upon the respondent is deemed to be complete. The matter shall be listed for admission. On thereafter, on 1/4/2025 also, no one appears when the matter was listed for admission. So, since the respondent has been given ample opportunity for their appearance, this court has no option but to take up this matter for admission. Start. Today. The case of the petition paragraph, the case of the petitioner is that when the first Kaba date
21/2011. Page 18.
Twenty.
21, 2011. The first Kabang Lordship,
Yes. yes.
21, 2011. 20 January.
On 21, 2011. Which Kaba?
Lordship,
Kaba, which village?
Sikatode.
The page where it was? Sikatode.
Yes.
There's only one. The Kaba
Sikatode GB.
the
Under the Sikatode GB.
the Kaba of Sikatode
Village.
village decided
Yes.
the land in question in favor of the petitioner. Stop. However, it was directed, and however, the Kaba decided that on payment of 25,000 per pura by the respondent, comma, it says purchase only. The
Has to be purchased by Jamo family.
okay. On purchase,
Meaning that if they want to take the land, they have to purchase from me.
it was further decided that on where it says that the land is to be possessed by the Jamo family.
Lordship, it is not written here, but the idea was that if they purchase the land from me, then only it would be revert to them. Otherwise, there was no need of the money. Lordship.
Okay. Then the Kaba decided the disputed land to be belongs to the petitioner. However, it was decided that the Jamo family is to purchase the said land from the petitioner at the rate of 25,000 per pura. Stop. On measurement.
Within 1 month.
Within 1 month.
Yes.
On measurement, the land measurement came out to be, where is the measurement you see?
Lordship, page 27. This is
Not 37,
page 27.
37.
27. Among measurement it is written.
27. Okay.
27.
Yes. The said on measurement, the said land came out to
The translated copy is also at page 28.
the area came out to be the land came out to be
In case of Taikta Singh Jr., 2 puras and 70 lusa. Then 50 lusa was used by the PWD road. So therefore the remaining is 2 pura and 20 lusa.
Measuring 1 pura, 2 bigger, 53 lecha. It should be lecha, I think. No?
I don't know, it's written lusa. I don't know how it's pronounced.
It's adopted from Assam.
I think they pronounce it lusa there.
And quantify the amount to be rupees 51,250. The said amount was to be paid within
1 month.
1 month from the date of
From today it is written. That is from the date of 21, 2011.
from 21 this is 22/1/2011. The respondent failed to pay the said amount to the petitioner. However, subsequently, the PI, where was the decision of the PI?
Lordship, page 86 is the English translation. Otherwise, it's at starts at page 82.
PI of the Office of the Sile Oyang Circle conducted another Kaba and reduced the amount of rupees 51,250 into 35,000. This was also not paid.
No, this lordship we did not agree.
Okay.
Also, lordship, after
Without,
this,
but,
lordship, just something I'd like to point out. After the amount was not paid initially, lordship, after the amount was
this you see the decision was in the month of January.
after the first kabang, after that amount was not paid within 1 month, there was a follow-up decision, which is at page 31, which I had pointed out.
Page
31. This is lordship on 24 February 2011. The original one is at page 29. The translated portion is at page 31. According to this, since it was not paid within 1 month, then it was decided that the land would be possessed by would be under the ownership of the petitioners.
Okay.
So
this decision was taken when?
On February, lordship, 24 February 2011. Subsequently, because as part of first kabang, that the land.
No, this is 20 January only, not February.
No, lordship, this is mentioning about the kabang. This is not the date of the decision. The date of the decision, your lordship, would find at page 29.
By the said order, it was further decided that in case the respondent failed to pay the amount assessed to the petitioner, the lane in question shall. Where is the decision?
Lordship, last page, or last paragraph, lordship, before the signatures. Therefore, the GB of Sikatode and Kabang Sakir decided that Taek Tasing Senior Junior shall possess their plot of land as marked by Kabang dated 21.
The land shall be possessed by the petitioner. Stop. It is submitted that the respondent failed to pay the amount assessed by the Kaba. Stop. However, on second Kaba was 31st March, 1st March.
1st March,
Okay.
2011.
On 1/3/2011, the PI of Chileoyang Circle conducted another Kaba without the knowledge and information of the petitioner. In the said Kaba, the amount of rupees 51,250 was reduced into 35,000 to be paid within 20 days from 1/3/2011. What else was decided?
Also that the previous Kabang dated 20 January,
Hmm.
they have affirmed this previous Kabang, only the amount has been reduced,
Okay, only the amount.
only the amount.
But then this was not affected you.
Lordship,
This did not affect you.
yes, Lordship, this did not actually
But then
affect
you
me.
have challenged it.
Lordship, problem is when I had filed for execution,
Okay.
citing this order,
Hmm.
the assistant commissioner has refused to execute the Kabang order.
Okay.
That is why.
The said Kaba, the said second Kaba was conducted without any jurisdiction. Start. The further submission of the council, the further contention of the petitioner is that the petitioner filed an execution petition before the, it says before the CEO, EAC,
Lordship, before the CO,
before the,
Assistant Commissioner Ruxin.
before the CEO Assistant Commissioner Robson for execution of the Kaba order dated 1/3/2011. And when else? 20.
Lordship,
Your application is for execution of which order?
execution
1,
of
3,
21, 2011.
21.
21, 2011,
20,
the first Kabang.
01, 2011. And there was a subsequent decision of this 21. Have you mentioned that? No.
No, Lordship.
Okay. However, by an order dated, where is the rejection order?
Rejection order is at page 81.
19/12/2023. This is also CO, assistant.
Yeah, the same authority
The
to which
CO,
I had filed.
Assistant Commissioner.
Yes.
Assistant Commissioner of which?
Ruxin,
Circle,
East Siang
Ruxin.
District.
Roxin East Siang District. Decline
Yes.
to execute on the ground that executes the decline the execution of the Kaba order dated 21/2011 on the ground that it was
On the ground that in terms of the second Kabang dated 1/3/2011, amount has been deposited in the account of, in the office of the circle officer.
on the ground that in terms of the second Kaba dated 1/3/2021, the respondent judgment debtor had deposited the deposited the reduced amount of rupees 35,000 before the office of circle office,
Yes.
Silewang. The office of the circle officer, office of the circle officer, Silewang, and the circle officer had already issued notice to the decree holder to collect the decreed amount.
Yes.
You did not collect.
No,
Okay.
actually I had no idea about this. In any case, Lordship, as per the order, on 24th of February, the matter was final.
Okay.
There was no, and in any case, they had no jurisdiction to pass this order, the second Kaba.
It is submitted that the second Kaba was decided without any jurisdiction and knowledge of the petitioner and petitioner. Okay. And since the earlier Kaba decision dated 21/2011 has attained finality, the second Kaba is without jurisdiction and as such is known, as such the same is known as star. Para. Okay. The petitioner having heard the counsel for the petitioner and on perusal of the records, this court finds that the matter needed to be the matter needed to be heard at length. Accordingly, the petition is this revision petition is admitted. So list this matter for hearing.
Lordship, next week.
Next week, I think let us give an opportunity.
Lordship, this is the third time that it's been listed after
No, now
notices were served.
for final hearing. Okay, list this matter after 2 weeks.
Lordship, can it be on the next week after this next week?
Okay.
That is on Lordship 28.
Okay. Is requested, come on, let this matter be listed on 28 May.
Yes.
Okay.
Lordship, long time back, I've already given this
No,
service.
next week, May 28.
Oh, sorry, not May 28. May 28 would be next week.
Next week,
June, Lordship.
June.
3rd of June?
Hmm?
3rd of June?
3rd June. Okay.
Yes. Obliged. Lordship, there is an interim order, it may be continued.
The interim order passed earlier shall continue till the next date. Oh.
Yeah, madam.
Yes.
On last occasion, CD was called for.
Your Lordship, I've just received a WT message, Your Lordship, informing that the IO of the case has proceeded to Chennai to attend the 11th National Conference.
Just a minute. What's this? It says?
That the IO of the case is in Tamil Nadu in Police Academy
Okay,
for some
so
conference. Your Lordship.
that case that it could not be produced.
Yes, if Your Lordship give us fix the matter next week, Your Lordship.
Sure.
On 29th, Your Lordship. 30 on 30.
Miss Jenny, I'm very quickly. The IO of the case is out of registration on 20 in Tamil Nadu, in the state of Tamil Nadu. Therefore, the case study could not be produced. Hence, pray for granting further time. Prayer amount. List this matter as requested, list this matter again on
30, Your Lordship.
30.
May.
Okay, 30. On which date? You produce,
CD, your lordship.
okay. It was a scanned copy.
We can see for, I can see for the scanned copy of the CD, your lordship.
Okay, on which date the scanned copy of the case diary shall be produced? Huh?
Deeply.
Much obliged.
Yes, my lord, we have been directed to FIR on 22, my lord, instead of 17. So, lordship, this order passed earlier on 16 may be allowed to remain, my lord, till next deadline. What is this? Additional affidavit? Additional affidavit in this anticipatory bail? Yes. This is for what? Lordship, because the work executed by the petitioners, they were not annexed. You were asked to attend when? On 17th. On 17th? Yeah, but due to some hectic schedule, we have been again directed to FIR on 22. So that means your statement could not be recorded? No, my this time.
Out of station.
Yes,
So I did not
that is why.
I did not inform the authority. I've just informed them.
Okay,
I may be given some time so that I can ask for the CV.
okay.
And since there was an order from this honorable court, for taking no coercive action, that may remain till the it is called form.
Okay. Mr. Opada. So this was communicated to you that it, the next date is for the appearance is fixed on 17. Yes. Okay. Mr. N. Father, Planning Council for the accused applicant is submits that the IO of the case has directed the accused applicant to appear before him on 17. Yes. 17 of May. No, 17 of May. Yes. But citing some inconvenience, we have been earlier you were directed to appear before. By someone dated 9/5. And yes. When you were asked to on 17. Okay, 17. Yes. That remains all. I think the earlier notice only remains as it is. No further communication was only telephonic conversation. Okay. You were asked to appear on 17. Yes. Who Nalopada, who submits that the accused applicant has been telephonically informed by the IO of the case to appear before him on 17/5/2025. Stop. Mr. Opada, Lanet, you are here from standing counsel.
Special public prosecutor.
Yeah, sorry, special public prosecutor. Yeah, special public prosecutor.
ACB.
Special public prosecutor.
ACB.
Okay. SC.
ACB.
Okay. ACB. Okay. ACB. Also submits that he is yet to obtain instruction.
No.
Okay. In view of the above, let the matter be listed. Again.
26.
26. 26.
The CD may be called for matter.
Okay. In view of the above, okay. Let the matter be listed on 26. On which date? The scan copy.
Well, no, the original CD.
Original, okay. The Special public prosecutor shall produce the case diary of the SIC, BS. Case diary. Okay. In the meantime, the interim order passed on 16/5/2025 shall remain till the next day. Okay.
Lordship, the same order may be passed.
Okay.
And,
May it please your lordship. Lordship, I'm appearing on behalf of P. Nair, lordship. He tried to mention this matter earlier in the day, but somehow he could not connect. Lordship, as per the on the last occasion, on the joint prayers of the party, the matter was listed on 19/6/2025. However, it has been wrongly reflected in the order. So, and in the daily in the case status, it is shown as 19/6/2025. So that is the reason why you could not.
Wrongly typed as 19/5.
5, yes.
It should be 19/6.
6, lordship.
Yeah.
So can this matter be fixed on 19/6, lordship?
Okay. Mr.
A. Tatak on behalf of
No.
PDNA.
Lani counsel for the both the Lani counsel for the petitioner, Mr.
A. Tatak.
And Mr. Lloyd. Lani PP are present. And some is that the prayer on 15/5/2025 was for fixing the matter on 19/6/2025. However, it has wrongly been typed as 19/5/2025, due to which the matter has been listed today. Accordingly, therefore, listing this matter on 19/6/2025. So, prayer allowed.
Lordship, interim may be continued.
List this matter on 19/6/2025. Stop. The interim order passed earlier shall continue till the next date. Okay.
Deeply obliged.
Obliged, Lordship.
Yes.
Okay.
May I please, Lordship? Yes.
Lordship, IA number 78/24 is with regards to Lordship an application under section 5 of Limitation Act. Lordship, the fact
I
of,
is for condonation.
yes, Lordship, condonation.
You have,
Lordship.
you're for the applicant,
Yes, I am for the applicant.
I'm responding.
respondent. You have any objection?
Yes, Lordship.
What is it? How many days of delay?
Lordship, 751 days.
Oh,
Lordship, the matter is that Lordship, Lordship may kindly peruse page number.
have you filed objection?
Yes, Lordship. Fine.
It's there.
Lordship, page number 24 of my main met appeal, number 1 of
Main appeal.
main met appeal.
This is whether this has already been registered.
Yes, Lordship. Lordship,
Now, the delay in filing this matrimonial appeal, only you have filed this condonation petition.
yes.
So how it was registered? It has been registered unless it is, the delay is condoned. It should not have been registered, isn't it?
Lordship, it will be registered, but on,
No, the number can be given, filing number, but then it cannot be registered unless it is allowed.
Lordship.
It cannot be,
Lordship,
isn't
that-
it?
with
Because
that-
first it has to be, the delay is to be condoned. Thereafter only in that delay condonation, if it is allowed, will be directed to register and list it. But it cannot be registered. It will cover the number. Supposing if it is not allowed, then
yes, it will be dismissed.
hmm?
It will be dismissed if it is not allowed. Lordship, without the main case,
Hmm.
Lordship, IA may not be registered. That is my understanding, Lordship.
No. Before registering, you will be given a number, filing number. It will not be registered. But then your condonation petition will be taken first. And if it is allowed in condonation, delay is condoned and allow you to file, then only it will be registered.
Okay. Lordship, that is, registry has registered.
Probably, this probably may
But
have to
I have,
change.
I have filed. it-
Anyway, if the system is going on here in this case, we will have to, I think,
Lordship.
we discussed again about this. Yeah? Because once registered, it all unnecessary. It is being registered,
Yes.
isn't it? So if it is not allowed, then automatically it will not be dismissed also, because it is not allowed. Even
Yes, Lordship.
yes,
May I come to the
yes,
facts?
please.
Lordship, the respondent is my wife.
Okay.
And as a petitioner, she have instituted a case under section 9, read with order 12A, rule 1 and 2, read with section 151 of CPC before the district and sessions court UPA for declaration for dissolution of marriage.
The wife has filed.
Yes, wife has.
Or the prayer of the wife, it was decreed.
Yes, Lordship. Lordship, but the fact of the case is that upon filing of this divorce, title suit divorce 13/21 before the learned district and sessions court UPR, notice was issued to me, the petitioner in this present application. However,
It was decided on contest or on?
no, ex-parte.
Ex-parte.
I have
Okay.
not been served with a notice. That is I have never received notice. Lordship. Lordship, may kindly peruse page number 25. This is the tracking consignment.
Page 35.
25 of my main application. 25. Lordship, this is the
25 is something.
25 tracking consignment.
Yes.
Yes, Lordship. Lordship, this is the tracking consignment I have downloaded from the Indian Postal website. Lordship, here in this tracking consignment, the event detail for this notice has been stated as item dispatch, not delivered. Lordship, in serial number not has not been given. Dated 9/10/2021. Lordship. Second time is given. Office not locking food. Event item dispatch. But Lordship, there is two different things. Item dispatch and item delivered. It has to be item delivered, Lordship. Item dispatch is not item delivered, Lordship. On production of this tracking consignment before the learned trial court on 25/10/2021, the learned trial court has passed an ex-parte order.
Okay, this is only item dispatched.
Yes, item dispatch.
Not delivered.
Yes, not delivered. I have never received.
So when this judgment was passed?
There is on 25.
Okay, thereafter.
Yes.
Proceeded ex-parte.
Yes.
Evidence adduced.
Yeah.
Passed this.
Yes. I was never.
But even after decision, then why 700 plus?
Yes, Lordship, I was having no knowledge of that because after obtaining this.
No, where is this,
I have explained in my delay application, Lordship.
this, which
Eh,
court, which court? Papumpara, UPR?
Yes, yes,
UPR.
UPR.
So where is your station?
I am staying
Where
at
do you stay?
I am residing at Nirjuli, Lordship. But my wife has deserted me since 2000, Lordship, 12. Thereafter, I have even one son. She has deserted me, and without my knowledge and consent, she has obtained this decree, Lordship. I have
No, you have, both of you have a children.
yes,
How many?
one.
Okay, one. Okay.
Lordship, I have explained.
How old that would be?
Lordship, now I think he is 14 years old.
You are in the department or?
No, no, Lordship, I am a villager, Lordship.
And then where the wife stays?
Wife, Lordship, she was a resident of Lordship.
Usually.
Yes, Lower Subansiri district, Yajali.
Now, where have you justified that when you have came to know about?
Yes, Lordship. Page number 5. Para 5 of my IA application, Lordship. Para 5. Lordship, each and every delay,
Okay.
Lordship, I have explained.
Wait, continue at 2.
Okay.
Okay. Yes.
Yes, may I continue, Lordship?
Yes.
Lordship,
Since when they are staying separately?
since 2016.
16.
Yes.
So,
She has
Yeah.
deserted me. My
but then why you are objecting? Why you want to object the divorce if since 2016, it's 10 years? more than
Lordship,
10?
she is mother of my child. She is my wife.
But the child is staying with whom now?
Child is staying with me.
Stay with you.
Yes.
What do you want now?
Lordship.
Stay, for example.
Lordship, this
Even if it is allowed also.
Lordship, she has deserted and she has left me. Lordship, I was the person who has given her education. I have
Maybe. But then since you are staying separately since 2016, what purpose it will serve? Now, even if we allow you also.
But Lordship, she has taken this divorce, Lordship, illegally, Lordship.
Lordship, may I submit, Lordship? Lordship, in the meantime, Lordship.
Just it was for information only, not connected with the condemnation petition. No. In the meantime, what?
Lordship, the respondent has already remarried again with another man.
See,
In the
that-
period of the 755 days.
Hmm.
Lordship.
That marriage is, Lordship, it's void, Lordship, because she is my legally married wife.
Now this seems only to cause trouble. It's not going to serve any purpose. He's remarried to some other person. But even what I'm saying is, even if it is restored, even if it is allowed also,
Lordship.
but what purpose it will serve? Anyway, so if you want,
In
but
marriage,
then if you
Lordship,
can
yes.
satisfy,
Yes, Lordship.
and anyway.
Lordship,
On where the ground you have stated?
Lordship. Page number 22 of my main application, main appeal. Page number 22, annexure 2. Lordship,
There is annex 22.
yes,
Okay.
page number 22,
So
annexure.
that one.
This is the
So
order.
These, of course, I have noted.
Yes.
Hmm.
Lordship, this is the first order. In this order, Lordship, this is the first order issued by the learned trial court, that is the Court of District and Session Judge UPR, that divorce petition is being filed under section 9 of so and so, praying for dissolution of marriage between the parties. Heart so and so. Notice issued. Next date fixed for filing of reply on 22/9/2021. Thereafter, 22/9/2022, so and so appeared for the petitioner, none appeared for the respondent's side. Again, next date is fixed for filing reply on 25/10/2021, Lordship. Thereafter, on this day, the learned trial court has directed the counsel for the plaintiff to take step upon the respondent. The respondent has taken a step through registered letter, but in page number 2024, it is reflected that the address has also been just written as Anya Colony, Nirjuli. Lordship, Anya Colony, Nirjuli is such a big area. There may be around more than 2,000 households, wherein the petitioner, the respondent or the petitioner of this present appeal, he is just a common person whose name is not at all popular. In Anya Colony, how a person of a postal department come and deliver this letter from this honorable court? It is just written as Anya Colony, Nirjuli, without any.
Which paragraph it is?
This is
In the address?
Yes.
Where?
Page number 35 also, you know, Lordship ordered 35. The address of the appellant is just Habu Talik, son of so and so, Anya Colony, Nirjuli, POPS Nirjuli. That is the only address, without any landmark, Lordship. This is the only address provided as per record by the respondent.
That is true.
Lordship.
This also
And-
could be seen that.
Yes, and
So such a long period, it's also
Lordship.
not possible that you were no knowledge about the.
Lordship,
case
I have
process.
absolutely, there is no way to, Lordship, in
But-
the petitioner, Lordship,
But ultimately, in your affidavit, have you stated that now you are remarried
Yes, Lordship.
in the objection? Have you stated?
Yes, I've stated.
Now you know that she is already.
yes,
married.
today only he has,
You just obtain instruction first, then
No, I have a clear instruction.
you have a clear.
Yes.
Still, he is
Yes,
ready to
yes.
contest.
Yes, ready to contest. Clear instruction. Just now I have taken out instruction. Lordship, even in her divorce petition, she has herself stated that in the year 2016, she has left from my matrimonial household and went to Shillong without my knowledge. And I have tried every possible way to locate her. But since I am a villager, and from Shillong, she again went to Gujarat. That is just now I came to know. Yes, Lordship. She has just left me.
That is why I'm saying.
Yes, Lordship.
She has left without your knowledge.
Yes, without my knowledge from Shillong. She left to Shillong 2016.
Now that if you contest, if you even you the order pass in your favor also, will you be able to control?
But Lordship, at least this decree of divorce, which she has obtained, it's Lordship, I may be allowed to contest.
Because if it is unnecessary, court also will not encourage. If it is knowingly only to harass the person.
No, Lordship, that is not my intention, Lordship.
Hmm.
My minor child, every day he is looking for his mother, but I have left with no answer, Lordship.
Okay, so the ground is that
Yes,
address is not correct.
Address is not correct.
It was
and-
only dispatched, received not there.
Yes,
Okay, what else?
absolutely
What
not,
else? What else?
not delivered.
What else?
Yes, Lordship, I have not given an opportunity to contest because the letter was not dispatched, not delivered to me. I have no knowledge. And despite of that, after obtaining the decree of divorce, had she informed me that I have obtained that decree, then also at least I would have been having the knowledge regarding the divorce, but she never informed me. Only in the year 2024, I have explained each and every delay in my IA under application.
No, para.
Yes. Para 5, page number 5, para 5 of my IS 78/24. Lordship. Married.
Page,
Page number
five.
page number 5, para 5 of IA 78/24. IA under section 5 of Limitation Act. Para 5. That the judgment and order was passed by the learned district Judge Upia on 24, 2022. And the appeal was supposed to be filed on or before 27, 2022. The respondent, after obtaining the ex-parte decree of divorce, although was not in touch with the applicant, never disclosed anything about granting of divorce or tried to meet her son who is staying with the applicant. The granting of divorce came to the knowledge of the applicant on 22, 2024 from the relative of the respondent, namely so-and-so. The applicant thereafter on 21 to 2024 immediately communicate with an advocate in Itanagar and ask him to make an inquiry in the court about passing of a decree of divorce against the applicant. The advocate in Itanagar made an inquiry in the court on 25 to 2024 and came to know about passing of impugned judgment. The advocate in Itanagar immediately informed the same to the applicant on 25 to 2024 over phone, and as such, the passing of impugned judgment have came to the knowledge of the applicant exactly on 25 to 2024. The advocate in Itanagar thereafter on 26 to 2024 has furnished the detail of case asking the applicant to obtain the certified copy of impugned judgment through one advocate. The applicant thereafter on 27 to 2024 engaged one advocate to get the certified copy of the judgment along with other documents related to this case. The said advocate thereafter applied the certified copy and got the copy on 28 to 2024 and handed over the same to the applicant on 2/3/2024. The applicant thereafter hand over the certified copy of the document to the present engaged counsel at Itanagar on 10/3/2024 for preparation of appeal in the High Court. The present engaged advocate, after going through the papers, has found that order of title suit divorce number 13/21 was not available with the record, and thereafter advised the applicant on 15/3/2024 to collect the either order sheet, including the ex-parte order passed against the petitioner in title suit number 13/21. The applicant, due to treatment of his brother, could not obtain the same immediately and asked the previous advocate to obtain the same. The entire order sheet of the case, subsequent order on 9/5/2024 and handed over the same to the present engaged counsel on the same day, that is on 9/5/24. The present applicant thereafter prepared the memorandum of appeal and connected petition. The appeal has been filed on 10/5/2024. There was a delay of 600. There is this delay of 663 is miscalculated. It should be 571 days.
No, 754. 597.
In preparing this appeal, that there is no negligence or laches on the part of the applicant to proceed with the case, and the applicants are prevent from sufficient cause in not filing the appeal in time. Lordship, here in this case, although there is a delay of 751 days, but there is no any negligence on the part of the appellant, as because the present decree impugned judgment and order passed on 24/2024. He has no knowledge at all. That is the only reason. So, Lordship, this is a sufficient ground as provided in the section 5 of Limitation Act to condone the delay, because the number of days may not be Lordship material when the reason provided under this application is Lordship sufficient. And Lordship, if the appellant is not given an opportunity, Lordship, he may be given an opportunity to contest the case, Lordship. Yes, because fraudulently, without my knowledge, she always remain away from the state of Arunachal Pradesh. I am the person who has financed her for her education, for her. But since 2016, she just went away from my home. And now also, I think she is living somewhere in Gujarat as per the affidavit filed today only. I came to know that she is in Gujarat.
She is not in the.
Yes.
Not in the state.
Yes, Lordship. There is no reason why, Lordship. There is no reason that why I did not know about that. I tried to make many endeavors. I went to my Lordship father-in-law's place at Yajali, Kipanyor district, inquire regarding her whereabout. But they are saying that they have no knowledge regarding the whereabout of the respondent. But surprisingly, I came to know that she has obtained divorce from me. And the reason for divorce is desertion. She is the one who has deserted me and obtained this divorce decree without my knowledge and consent. So my application may be kindly considered, Lordship.
Yes.
Yes, Your Honor. As per the record, Your Honor.
Lordship, in their objection, they have objected only regarding the dates of delay. And secondly, they are objecting that since they have sent the notice in my address, so it should be presumed that it is duly delivered or served. That is the only objection. I have gone through it. Apart from that, they have no any objection, Lordship. They are just saying that the date of the delay, there is some variation in the dates, number one. Number two is that since they have sent in my postal address, it should be presumed that the notice has been duly served. That is not the strong ground, Lordship. May be rejected.
May I please, Lordship?
Yes.
Firstly, Lordship, there is a delay of 754 days, but they have written as 663 days in their petition, Lordship.
Okay.
And Lordship, as per the record, Lordship, on 2 occasions the notice was served into the correct address of the appellant. That is on 28/8/21 and 22/9/2021. And you know, as per the section 27 of the General Clause Act, Lordship, when a service is sent into a correct address, it is deemed to be presumed to be deemed as served, Lordship.
No, according to him, it's not the correct answer, correct address.
Usually, this is the correct.
The trade record says that it was only dispatched, not shown as delivered.
Yes, Lordship.
What do you say? What do you have to say about that? It's not it was only dispatched, showing dispatch, not the delivery.
That is the
Then, unless it is delivered, how would the respondent know?
So the presumption can be done when is
How if you have not written the correct address and then it was not delivered, how it can be presumed?
As per,
If it was a correct address and delivered, whether received or not, the fake record it shows that it was delivered, then it can be presumed. And of course, if the address was correct one.
this was the only address given by the respondent during the time of.
See, she doesn't know. They were not together. She did not care to collect the correct address.
You know, she is mother of my.
But then whatever maybe, but now she is married.
Yes, Lordship.
Not here, not in the state.
Lordship, she is working there at Gujarat.
I have no idea how you are going to gain out of this.
Lordship.
Lordship, this will
Although,
serve no any purpose when this petition is.
Lordship, that is regarding the
married, it will be,
yes.
of course. Okay, hard, Mr. Kaba, Lord Counsel for the petition. I was hard. This is item. Mr. Jisakia, Lord Counsel for the respondent, start, para. This is an application filed under Section 5 of the Limitation Act for condoning the delay of 663 days in preferring the connected appeal. Start on para. The ground for delay in preferring the connected appeal has been explained in para 5.
Yes, Lordship.
Of the condemnation of the petition start.
Each and every delay has been, day-to-day delay has been explained.
The Land Counsel for the petitioner states, submits that the impugned judgment and order dated. What was the impugned judgment order dated?
24/2022.
24/2022.
Yes, Lordship.
Was passed. Sorry, that's the. The Land Counsel for the petition submits that what is the number of the case?
Lordship, title suit divorce number 13/2021.
Divorce number
13/2021.
2021 proceeded ex parte based on where was the document that shows dispatch?
Lordship, that is tracking consignment dated 9/10.
Based on the tracking consignment dated 9/10/2021 produced before the trial court. However, the tracking consignment dated, however, the said consignment only shows item dispatched. Item dispatched, It is permitted the item dispatch is not equal to item delivered. As such, the notice was never received by the applicant respondent. However, the Lanark Court proceeded ex parte and decreed the suit on 24/2022 start. it is stated that the after the granting of divorce on 24/2022 came into knowledge of the petitioner only on 22 when it was came into knowledge of the respondent through his relatives only on 21/2/2024.
Yes, Lordship.
Or 22/2024. Knowledge of the applicant on 20,
Yes,
20/2/2024. Thereafter, on 21/2/2024, the petition, the applicant immediately communicated with the advocate with a view to file appeal.
Yes, Lordship. Matrimonial appeal. Matter.
What is this? The applicant immediately informed the 25/2/2024. What is this?
25 to, that is regarding when the relative of the appellant got to know regarding the passing of this divorce decree, then he has informed the applicant. And thereafter, the applicant has engaged an advocate at Itanagar for obtaining or verifying the details regarding this title.
Thereafter, the applicant engaged the advocates to verify and to verify the detail and to obtain the documents from the court. On 27/2/2024.
Yes, Lordship.
Thereafter, the engaged advocate obtained certified copy of the judgment on 28/2/2024 and handed over the same to the applicant on 2/3/2024. After that, the applicant engaged the advocate to prepare appeal before the High Court, which took another against the PS divorce, against the judgment and order dated. What was the date? Judgment and order dated
22/2020. 24/22.
24?
24/2022.
Okay.
Yes.
And the entire order sheet and the judgment was collected then obtained on 9/5/2024. And thereafter, on the next date, that is on 9/5/2020.
Yes.
And thereafter, on the next date, Then on, that is on 10/5/2024, the appeal was filed.
Yes, Lordship.
And in the process, there has been a delay of 663 days in preferring the connected appeal. It is submitted that there was no negligence or laches on the part of the applicant in filing the appeal. So the non-counsel for the respondent, while referring to the objection filed by the respondent, submits that a first step was taken on 22/9/2021. And the second step was taken on 30/9/2021. And based on the tracking report, the court resumed the notice having served and proceeded ex-parte. And passed judgment on 24/2025. The further submits that, in fact, there is a delay of 754 days. And not 663 as stated by the applicant, staff of para. Both the Land Council for the parties, I have also perused and considered the statement stating the ground for delay in preferring the connected appeal and seeking condonation of delay of 663 days. Staff on para. On upon hearing the parties and on perusal of the records, this court is of the opinion that there is no clear evidence that the notice was served upon the respondent, as the address of the applicant, the respondent, is also not clear. The tracking record is annexed also shows that the consignment was dispatched. There is no record of the delivery of the consignment. In view of the above, this court is satisfied that the applicant was prevented by a sufficient cause for in not preferring the connected appeal within the stipulated time. Stop. In view of the above, the delay of 663 days in preferring the connected appeal is hereby condoned. Stop. In the interest of justice. Stop. With the above, this IS stands disposed of. Stop. The registry, okay, is directed to list the connected, sorry, since the matrimonial appeal has already been registered, the same shall be listed after 2 weeks, okay, for admission. Okay.
May I have a small prayer, Lordship?
Hmm.
Lordship, since the matter has been admitted, Lordship, I have
Not admitted.
Lordship, I have one more misapplication.
What application is this?
Lordship, for
It has been listed. Has it been listed? Let it be listed along with the appeal.
Okay.
If you have, it's a what?
Okay.
What
Lordship,
application?
after
Stay petition.
Yes, Lordship, after 1 week.
Hmm?
After a week, if possible.
After a week. Okay.
Fix date, maybe.
Hmm?
Fix date.
You have already filed the IA.
Yes.
Where? It has not been listed, it appears.
Lordship,
It is only matrimonial and then this condonation, delayed condonation petition only, which has been listed, not the IA for stay.
I have filed, but they have not registered. Maybe because the
It will be registered now only because.
yes.
Because how can that be registered? This also it should not have been registered unless it is condoned. After condonation only this would have been. Now in the condonation petition only we used to direct that the registry is directed to register the appeal and a list for admission.
Lordship.
IA cannot be listed at the moment. You file it and then get it listed along with the appeal. Okay.
Okay. Okay.
Yeah, next.
Deep knowledge.
Whether the respondent is appearing? No. How many respondents are there?
There is one respondent.
Only
Only-
sole respondent,
Yes, Your Honor.
not appearing.
Wakalatnama has submitted.
Miss
A. Rai.
A.
Rai.
Right. Your name is there?
Yes, Your Honor.
Item 16.
Yes.
Okay, yeah, A. Right. Land counsel for the petitioner. None appears on behalf of the respondent, although the office note reveals that indicates that the advocate has filed wakalatnama on behalf of the sole respondent. Stop. In absence of the respondent, the matter stand adjourned. Stop. List this matter after
After 2 weeks.
2 weeks.
Good evening.
Okay, 1%. Although the name of the respondent has been reflected in the cause list. Okay, his name is already there. Yes.
May I, Lordship? Lordship, I may be allowed to fresh step for respondent number 2.
In view of the office note dated 17/5/2025, Mr.
B. Sibo,
B. Simo, and counsel for the petitioner, prays for allowing him to take fresh steps upon the respondent number 2. Start. Prayer allowed. Steps upon the respondent number 2 by a register post which AD as well as by usual process within a week from today. So let this matter be listed after 3 weeks.
3 weeks. Yeah. Of
May I, Lordship, there may be interim.
There is interim.
Interim may be continued.
The interim or the past earlier shall continue to the next stage. Okay.
Obliged.
Your Lordship, I would like to mention item number 16, there is interim that may be continued.
Item
16.
16.
Yes, Your Lordship.
Okay. Item 16. The interim or the past earlier shall continue to the next date of listing. Okay.
Develop.
Lordship, I am for the petitioner.
Yes.
Step has been taken.
Still awaited.
As per record, notice was issued on 17th March 2025.
It is still awaited, huh? Notice upon.
And it has been received by the respondent.
Where do we?
So, Lordship, as per record, it is received on 26/4/2025.
Service report in respect of sole respondent is still awaited. What I could see is, yeah. Notice was issued earlier.
As per tracking consignment record, it is.
Now you see, huh? As per?
As per tracking in this one, consignment, postal consignment.
Where is that?
I have confirmed it from the registry. It is
Where do
received.
we find? This one. This is only showing that you have taken steps. You have to find out the status from the tracking record. Okay. Where from you are submitting that it was delivered? It was not delivered. Okay. Mr.
PTC.
Line counsel for the petitioner. The service upon the respondent number, the sole respondent is still awaited. Or what do you want? You want to take fresh steps?
Yeah.
Okay.
First step may be allowed.
Still awaited.
this service
In view
be
of
allowed?
above, the line counsel for the petitioner prays for allowing him to take fresh steps upon the sole respondent by way of dusty mode. A dusty service. Stop. The prayer is allowed. The petitioner shall take steps upon the sole respondent by way of dusty mode to be routed through the registry and to file affidavit to that effect. Okay. That's within a week. Okay. Within a week. List is matter after 3 weeks. Okay.
Much obliged.
Yes.
Lordship, herein, Lordship, conducting counsel, Mr. Pang even lags at the court number 1, Lordship.
Okay.
And Mr. T. Tapak, he is also not here, Lordship. Also. And this matter may be fixed on 3rd June, Lordship.
3rd June.
Yes, Lordship.
No objection. Okay. Mr.
The loaner. My name is not
Learned
yet.
counsel for the appellant. Prays for adjournment of the matter for the day and to be listed on 3rd June. To which Mr.
BCO.
BCO, learned counsel for the respondent, learned counsel appearing on behalf of the respondent has no objection. Accordingly, the prayer is allowed. Let this matter be listed on 3rd June. Okay.
Fabulous.
Yeah, my lord. Yes, this is the first appeal, my lord. Against the order passed by the district judge. Hello. Here, my lord, the simple question is, my lord, whether on the mixed question of fact in law, my lord,
Who appears for the respondent?
no one, my lord. Steps has been taken, my lord.
No, there,
Yes, my lord.
no one.
Yes, my lord. My lord, on 23/5/2023, I was allowed to take justice service, my lord. Now on 9/1/23, 23/5/23, my lord.
2023.
Yes, my lord.
Since 2023, it has not been listed.
It has been listed, ma'am. Time to time, it has been listed, ma'am. On 9/1/24, ma'am,
No.
notice upon the respondent
No,
was
it-
deemed served, ma'am.
No one appears.
No one appeared. And then on 1/5/24, yes, ma'am. 9/1/24, ma'am. 9/1/24, ma'am. Order dated 9/1/24.
24.
Yes, ma'am. Notice up. I have taken justice service upon the respondent, ma'am. And notice upon the respondent was deemed served, ma'am.
It was deemed self.
Yes, ma'am. On 9/1/24, ma'am.
9/1/24.
24.
For the steps, this is justice
Yes.
received by somebody else, not by the respondent. Huh?
Yes, my lord. But the respondent was not there, my lord, was not present. So why I have taken service of notice upon.
No, not even the family, but then this will be received by sister-in-law.
Yes, my lord. Who resides in that house only?
Reside in the same house.
Yes, my lord.
Is it proper to go ahead with the ex-parte hearing?
Yes, my lord.
What
On,
is this?
on my lord, 18/9/24, my lord. On order dated 18/9/24, this honorable court has observed that on the next date, my lord, the matter would be heard on its own merit, my lord.
You're challenging the judgment and order dated?
Yes, my lord. Passed by the district judge, my lord. My simple question here is, my lord, whether on a mixed question of fact and law, whether the suit can be decided on preliminary issue, my lord.
Can be decided?
Yes, whether mixed question of fact and law can be decided as a preliminary issue, my lord.
Okay.
On, my lord, on
After
preliminary.
framing preliminary issue, only the matter was decided.
Yes, my lord.
Not after trial.
No, my lord. So why before this honorable court? My lord,
So
here
the fact may not be able to decide.
but fact, my lord, fact is that, my lord, I have filed a restitution petition, my lord, before the district judge, my lord. Now the respondent has filed their written statement stating that there was a kabang.
Respondent there, the respondent contested.
Yes, my lord. Respondent contested and respondent claimed that there was a kabang and the marriage has been dissolved between the petitioner and the respondent, my lord. Now I say, my lord, there was no kabang. No kabang was ever held. Now it is a disputed question of fact now. Now, The law will be decided on the disputed question of fact, my lord. Now, on the disputed question of fact, my lord, this honorable court, learned court below, my lord, has passed the judgment, my lord, by dismissing my petition, my lord, my suit, my lord.
Now, according to the respondent,
Yes, my lord.
the Kaba
There,
dissolved the marriage.
yes, my lord. Now, my,
Which year? Which year?
my lord,
Which year?
my lord, Kaba decision, my lord, they claim, my lord, it was on on 2/9/2019, my lord.
19.
Yes, my lord.
So since then you are.
No, my lord, what I say, my lord, there was no Kaba, my lord. So it is a disputed question of fact, my lord. Now, evidence has to be laid, my lord. Without ascertaining my lord, the existence of this Kaba decision, my lord, the learned court below has directly passed the order. My lord, may please come to page 78, my lord. This is the Kaba decision, my lord.
78,
my lord, of my appeal petition.
This is agreement only.
This is the Kaba decision, my lord. Page 78.
78.
Yes, my lord.
Kaba decision.
78, my lord.
So according to you, there was no Kaba decision.
No Kaba. And of all, my lord, and of all that, my lord, please come to page.
Where do we find the original one?
My lord, this one is the original one.
Is this a translation or the original is in, original itself is in English? No, original is in.
Yes, my lord. No, my lord, may please come to para 2, my lord, of the page 78, my lord. This Kaba decision, my lord.
Page
78, Kaba decision.
Yes.
The second paragraph. The AP Ragmukh so and so knows a complaint before the deputy commissioner so and so against Srimati Yame Padu, my lord. Daughter so and so alleging that C Yame Padu, my lord,
against
has
just a minute.
Against
Complaint before the deputy commissioner C Yomi district
against Sri Yame
against
Padu.
Yame.
Daughter of so and so.
So who is
Alleging that C, my lord, has an extramarital affairs with my husband, my lord. And she kept him as her husband. After receiving the said complaint, the deputy commissioner so has issued an order dated 14 August 2019 for the settlement of the case, my lord. Now, the issue was, my lord,
your for husband?
I'm the wife, my lord.
Your for later.
I'm the wife.
By which name?
I'm Yapi Ragmukh, my lord.
Yapi Ragmukh?
Yes, my lord.
Just a minute. That one. 40. No, is it something? It was
this dispute between
it was before,
I have filed
before
a
the
complaint.
additional session code Basar also.
Yes, my lord. My lord, this my husband, my lord.
And there also the wife. It was decided in favor of the wife.
My lord, the
wife means
suit was filed by the respondent for a decree of divorce before the additional district judge, my lord, Basar. It was dismissed.
You are Yapi Rangmukh.
Yes, my lord. It was dismissed, my lord.
Huh?
It was dismissed, my lord.
Additional has been dismissed and the judgment was in favor of. Okay, so divorce filed by the husband. It was dismissed.
Dismissed, my lord. Holding that the law of divorce act will govern us, my lord. as we are Christian, my lord. My lord, may I kindly appreciate para 2, my lord. Para 2 itself says there was a dispute between me and one Srimati Yamepadu for extramarital affairs. There was no occasion for settling the dispute for dissolution of marriage, my lord, between the respondent and the petitioner and the appellant, sorry.
It was an amicable settlement. This Kaba decision.
Kaba decision, my lord, what I say, my lord, there is no existence as such of this Kaba decision, my lord. So, my lord, to ascertain whether this Kaba decision exists or not, my lord, evidence has to be like, my lord.
See, what about this order?
My lord.
This order dated 14 August 2019.
Yes, my lord. Yes, my lord. My lord, 14 August, page 1110, my lord. 1110 is there. Now, before that, my lord, may see the complaint. The genesis, my lord, is it page 108, my lord, of this 14 August, my lord. So
110, just a minute.
108, my lord. This is the genesis.
Now, after this order, this was order on 14 August, and then this Kaba decision is on
this Kaba decision
date.
Page 78, my lord. It is of 2 September. My lord.
2 September.
Yes, my lord.
14 August constituted, and 2nd September, HGB, Tadugram, Lipo,
My lord, may kindly appreciate, my lord, we are alleging that this Kaba decision is a manufactured document.
No, see, just the order clearly says
yes,
that with the constitution, these persons whom
between the appellant, my lord, between the appellant and Miss Yamepadu, not against the respondent, my lord.
Yes,
Not at all.
it was allegation.
Yes, my lord.
Against
Yamepadu,
that she has
extramarital affairs with my husband.
She has kept the respondent as her husband.
My lord. No,
the husband has kept her as a second wife.
My lord, the dispute was between me and Miss Yamepadu, my lord. There is no question of, my lord, resolution of marriage before the
dispute was between you.
Yes, my lord.
What is the decision here?
My lord, the matter has not been settled till date, my lord. I have stated in my affidavit, my lord, the matter has not been settled, my lord. No order has been passed, my lord.
No, by this Kaba decision. This Kaba decision is the impugn order.
Well, yes, Kaba decision.
You are agreed by then what?
I'm against the order passed by the district judge, my lord, because the validity of this Kaba decision has to be ascertained by leading evidence, my lord, not by mere statement, my lord.
Okay.
So since it's a disputed, this existence of this Kaba decision is disputed question of fact and law, my lord. Now,
no,
because my writ petition, my restitution petition has been dismissed
no,
on the
subsequently petition was filed before the district judge.
No, my lord, this Kaba decision, my lord, the principle of law is that, my lord, on the basis of plaint only, order 7 rule 11 can be invoked, my lord. In my plaint, my lord, there is no whisper about this, my lord, Kaba decision.
Who filed?
I filed, my lord, for restitution, my lord.
Restitution?
Yes, my lord. Now, my husband, my lord, the respondent hearing, he filed a written statement stating that there was a Kaba decision. I said there was no Kaba decision. Now, there is a disputed question of fact now, whether this Kaba decision exists or not, my lord. So for that, my lord, the evidence should have been laid.
What the Kaba decided.
Kaba,
According-
as per the Kaba decision,
According to you, of course, there was no Kaba, but then what the Kaba decided here?
as per the Kaba, my lord, the Kaba has nullified our marriage, my lord. Now, there are two,
So
my lord.
that means divorce.
Yes, my lord. It is
Nullify means it was not a.
the marriage was dissolved, my lord.
Okay, dissolved.
Yes, my lord.
Okay.
Now, my lord, here also, my lord.
So as per this Kaba decision, marriage was dissolved. Dissolved.
Yes, ma'am.
And hereafter only you have filed for restitution of conjugal right.
My lord, what I am claiming, my lord, what I am stating is that, my lord, there is no Kaba as such, my lord. So it has to be verified through evidence, my lord.
No Kaba, but then okay, let us assume that there was Kaba.
Yes, my lord.
And you filed for restitution only after this only, otherwise.
Yes, my lord. Yes, my lord.
After this issue.
Yes, my lord.
This was decided on
This was the Kaba decision on 2/9/2019, my lord.
19.
Yes, my lord.
And then restitution petition filed on
Restitution petition, my lord, was filed on 2020, my lord.
20.
Yes, ma'am.
I think, Mr. Pinker.
Yes, my lord.
Need to be contested. Other side has to be heard.
My lord. One principle, my lord, I want to show, my lord. One principle.
So
I will read only one paragraph, my lord.
certain matter cannot be decided.
Yes, yes, ma'am. One paragraph I will read, my lord. Here in, my lord, Ramesh Desai, my lord, case, my lord, the Honorable Apex Court has heard, my lord. I will read only the relevant portion. Though there has been a slight amendment in the language of Order 14 Rule 2 CPC by amending Act 1976, but the principle enunciated in the above quoted decision still holds good, and there can be no departure from the principle that court confers no jurisdiction upon the court to try a suit on mixed issues of law act as a preliminary issue. And where the decision on issue of law depends upon decision of fact, it cannot be tried as a preliminary issue. Now, my issue, the principle of res judicata was applied in my case. Now, the existence of that fact has to be taken account for applying the principle of law. Now, when the existence of that fact, that Kaba decision is itself in challenge, now how can my suit can be dismissed on preliminary issue?
Now, Kaba itself was challenge means?
Existence of Kaba. I say there was no Kaba.
No, where did you, have you challenged that?
No, not challenge, my lord. No, I was not in knowledge because there is no Kaba, my lord. No Kaba was ever held, my lord. I have also filed review petition before the district judge, my lord.
Now, in your petition, you never mentioned about the
Kabang, yes, Kabang, my lord.
Okay. So the respondent brought.
Yes, my lord.
Is that there was a Kaba decision.
Yes, my lord.
So according to the respondent, barred by the res judicata.
Yes, my lord.
And then based on the Kaba decision,
my lord,
submission of the land council on behalf of the respondent.
Yes, ma'am.
Saying that there was a Kaba decision, so this cannot apply. So
my lord.
Then the preliminary issue framed.
Preliminary issue, yes.
Issue framed.
Yes, my lord.
Okay. So whether
only on the maintainability, whether the suit is maintainable.
Only on
maintainability, man.
Maintainability.
Yes, my lord. So regarding res judicata also.
Decided only saying that it was already decided.
Yes, my lord, the respondent said yes, the matter was decided.
Huh.
The marriage has been dissolved by the Kabang. So I said there was no Kabang. So even, my lord, after passing of the judgment by the district judge, I have again filed review petition stating, my lord, some facts I brought to the knowledge of the court. My lord, page 84, may kindly see, man. Page 84. This is the money receipt, my lord. Page 84. There have been so many manufacture of documents, my lord. He also annexed this money receipt, my lord. Page 84, my lord. He said, as per the Kaba decision, he has to pay me 13 lakhs, my lord. So he has paid me 13 lakhs, which was again returned to him by 1 GB, my lord. Page 84, my lord. May I read, my lord? On 12th day of September 2019, I, Sri Libo Ragmuk so and so, resident at Tagu village, received after a sum of rupees 13 lakhs from Tagamruchi as GB Tadugitu village, which was given by me on the date of 4th September for the divorce compensation to Srimati Yapi Ragmuk of Tato, who was wife of Libo Ragmuk. Malot, this page 84, Malot, the money received, Malot, this is of 12/9/2019, Malot. Now, against this, Malot, I made some query, Malot.
So this is how it is connected, this money received.
Money received, Malot, he says, Malot, I have, as per the, Malot, this Kaba decision, he has to pay me 13 lakhs as an alimony, Malot.
Okay.
So he had handed over the 13 lakhs to one Tagamruchi, Malot, who is the GB. Now, GB in this, Malot, page 84, has returned the money to the respondent herein, Malot.
Saying what?
Saying that I have not received, Malot. So he is returning the money to the respondent now.
Okay, so it was offered to you.
Yes, but I denied it.
Refused.
Yes, sir. Now, my lord, interestingly,
That means you knew that
the
Kaba.
This is not my statement. This is not. This is the statement. This is the record brought by the respondent, my lord. Not by me.
But then you say that
Yes, my lord.
You refuse to accept.
My lord, we kindly see, my lord, date. This, my lord, the judicial stamp paper date is of 12/9/2019, my lord. My lord, may see money received 12/9/2019. Now I made an inquiry, my lord. May please come to page 111, my lord. This stamp paper itself was, my lord, issued on 13/9/2019, my lord. There has been manufacture of documents, my lord. Please come to page 111, my lord. 111, my lord. So I filed an application, my lord, before the district treasury officer, Alo, my lord, for furnishing of this, my lord, date of this, my lord, issue of this stamp, judicial stamp paper, my lord.
Stamp paper.
Yes, my lord. The date is of 12/9, my lord. Date, this stamp paper, my lord, contains, my lord, stamp paper, yes, my lord. It is also in page 113, my lord. My lord, may see page 113. The stamp paper is there, my lord, of 12/9/2019. Page 113. The same 84, page 113 also I have like, my lord. Money receipt of 12/9/2019. Now this money receipt, my lord, was issued by the treasury officer of Alo, my lord, on 13/9. My lord, page 115 is, my lord, the copy furnished to us. Page 116 is the type copy, my lord.
It was, that means.
Release, it was issued on 13/9.
Typed later on only.
Yes, my lord. The date, there is so many differences in the date also. Money receipt of is of 12/9/2019. The issue of this stamp paper is of 13/9.
But you yourself admit.
No, I'm not admitting.
It was offered to you.
No, I'm not admitting. This
did not.
This is the stand. This is the stand of the respondent, my lord, not my stand, my lord.
Okay.
This was the stand of the respondent that they have also.
So your stand is that you have never been offered.
I am not in knowledge of this Kaba decision, my lord.
Okay. Anyway, but then hearing of the other side will be necessary.
Not many chance has been given, my lord.
So many this comes this relates to the fact because you are also, you see, this fact that the receipt, this stamp paper,
yes, ma'am,
was obtained on
13/9,
but the money received is dated on
12/9, yes.
So which is
so, my lord, this clearly gives the
prior
impression
to the obtaining of this judicial stamp.
Yes, my lord. There is clear manufacture of documents by the respondent, my lord.
There is a fact involved.
Yes, ma'am.
Opportunity is to be given. So what do we do? So these, even if any order pass affecting them, probably it will not survive because the steps also says it was received by not by him. It was received by some other person. Now tomorrow, if they refuse, if they deny that, saying that she's not staying in the same house where I stays, it will be difficult for you. Or even though if we pass any order also. But then you have to ensure that it was really received by him, and it was delivered and received by him.
Otherwise, my lord, CPC, my lord, CPC. My lord, I may be allowed to take service of notice upon the respondent through the advocate, my lord. Order, CPC, my lord. Order 4, Rule 3.
That is what I'm saying.
Yes, my lord.
Maybe that is there. In normal cases, it will be treated as deemed as received.
Yes, my lord.
But then here's the case where facts are involved,
my lord,
where the presence of the advocate for the other side would also be necessary, because fact one side, it will be difficult.
Well, facts, well, we are disputing the entire facts, Malad, because that is why I'm seeking trial, Malad. My prayer may be kindly.
That is why, because according to you, the case is in your favor. So ensure that his presence or non-representation
Yes,
is
sir.
properly means justified.
Otherwise, Malad, I may be allowed to take step upon the, again, respondent through, Malad, the council, Malad.
That will be better.
Yes, Malad.
There, they have a council, earlier council.
Earlier council, yes, Malad.
That will be better.
Yes, Malad.
And then he will inform you that I am no longer, but although I
At least he can convey, Malad. to
yes,
the-
he can convey, because till now he was there.
Yes, Malad.
That can be.
Malad, may kindly invoke rule 3, Malad, order 3, rule 4, Malad, CPC, Malad.
What is that?
Where, Malad, a decree, Malad, counsel appearing in the court can also be furnished with the Malad, the notice, Malad. Order 4.
Order?
Order 4, Malad, rule 3, Malad.
No.
It is order 4, Malad, notice.
Order 4
Oh,
doesn't.
sorry, Malad. Order 3, Malad. Order 3, rule.
Yes.
Service of notice, Malad.
That can be, that can be.
Yes, Malad. Malad, order,
Or
rule 4, Malad. Malad.
or by way of substitute, by publishing or anything. If you don't want to publish, that can also be done, huh?
Malad, may I see order 4, or order 3, rule 4,
Yes.
sub-rule, Malad, C. C, Malad.
2C.
Yes, Malad. 2C, yes, Malad.
Can you read?
Yes, Malad. So I can also, Malad, serve a copy of notice upon the Malad respondent through his.
What it says, can you read it?
Malad. Order 3, Malad, rule 4, appointment of pleader, Malad. Rule 4, Malad, appointment of pleader, Malad. Sub-rule 2 says every such appointment shall be.
Two.
Yes,
Every
Malad.
such
Sub-rule
appointment-
2.
Yes.
Yes. Every appointment shall be filled in the filed in court and shall for the purpose of sub-rule 1B deemed to be enforced until determined with the leave of the court by writing signed by the client or the pleader as the case may be and filed in court, or until client or the pleader dies, or until all proceedings in the suits are ended, or as so far as regards the client. For the purpose of this sub-rule, the following shall be deemed to be proceeding in the suits. Now see, an appeal from any decree or order in the suit.
Now, where is the provision that you can serve the respondent through his
Like,
earlier
he will be continuing as a pleader, Malad. By this, Malad, to my understanding, Malad, as per the interpretation of rule order 3, rule 4, Malad, sub-rule 2C, Malad. For the purpose of this sub-rule, Malad, the following shall be deemed to be proceeding in the suit. An appeal from any decree or order in the suit. Malad.
Okay. Hi, Mr. B. Teacher, Lion Counsel for the petition, appellant staff. By which order it was earlier?
Malad, 9/1/24, Malad, notice was deemed served, Malad. Was deemed completed, Malad.
And submits that by an order dated 9/1/2024, the notice upon the sole respondent was received by his sister-in-law And they are, and thus it was. And in view of the above, and in view of that, in view of that, the service upon the sole respondent was deemed complete. However, no one appears on behalf of the sole respondent for the for the end of justice, the learned counsel for the appellant. Praise for allowing him to serve serve one more notice upon the sole respondent through his
Counsel.
advocate who appeared earlier before the trial court.
Yes.
So, this is under provision.
Order 3, Rule 4, Sub-Rule 2C.
Order 3.
Yes. Order 3, Rule 4. Sub-Rule 2C.
No, it's not sub-rule 3.
Sub-Rule 2, Madam, Sub-Rule 2. Rule 4, Sub-Rule 2. 2C. 2C.
2C.
Yes.
Okay. The prayer is allowed. Notice upon the respondent through his counsel by a registered post with AD, as well as by
Can you see? Dusty, Madam.
Dusty?
Yes, Madam.
Okay.
Because he.
By way of Dusty service within 2 weeks from today. And file affidavit to that effect. So, list this matter again after 3 weeks.
Obliged.
Yes.
No, item numbers 21 and 22 are analogous in the sense that they arise out of the same suit, my lord. I've been recently engaged, my lord. The difficulty is the memo doesn't contain all the evidences.
Okay.
Now the lower
Whether
court-
record was called for?
records have come here, but I could not really obtain the certified copies. It's a
Okay.
bulky record. So perhaps referring to the LCR would be a little difficult.
Okay.
If your lordship permits us, we can take certified copies and then maybe advance our arguments.
Certified copy can be allowed by the High Court?
Yeah, we'll take it out on our own. We'll procure it. We'll procure
Okay.
it. So if your lordship accommodates us for
Okay.
today, we can procure the certified copies and advance the arguments. In fact, there are 2 appeals.
Okay. Mr.
I'm BD Decker.
Hmm?
BD Decker. I've recently engaged.
Okay. So, Mr. He has recently been engaged to represent the respondent number
Respond, all the respondents.
Okay, all the respondents.
All the respondents.
And although you have you don't have a record.
I'll procure some, your lordship.
Okay, and some is that the records are yet to be procured. Therefore, praise for some time. We pray for accommodation to obtain the records. So obtain the records. Start. Then
Now, may it please your lordship?
Yes.
I heard them. Now, in this case, already some substantial question of law formulated, but that is not enough. Some vital questions remain to be formulated. That may kindly formulate today. I have given it in the synopsis itself.
Okay.
Narrated everything.
Have you received the copy?
I've received the copy.
They have
Yes.
the copy, everything. Yeah, I'll cooperate with them. All right.
Okay.
The substantial question of law.
Already formulated, sir.
Partly formulated. Partly formulated, partly remain. So that is given in the
No,
synopsis
it was a
itself.
substantial question.
Everything
also
explained.
was framed earlier based on your pleadings, I think.
Exactly.
So after hearing, can it be framed now or it will be after hearing?
The questions are already framed. So in the wisdom of the court, those were the substantial.
Already
questions.
framed, three questions already framed.
Okay. And how many
And-
more questions you have according to you?
That order reflects that the court may formulate further and other
Yeah, that is
substantial
there.
question of law. That is there.
That will be that will be according to my understanding. It will be only at the time of hearing only.
All right.
Okay. The prayer not objected accordingly. Let the matter be listed again after.
Can I pray for a fix?
Yes, yes. When?
Maybe on 3rd of June if it's not in.
3rd June.
Date to call.
19 June. Okay. Okay. Prayer not
Let's
objected.
make
Okay.
it because otherwise.
As requested by both the learned counsel for the parties, let this matter be fixed on 19th. 19. Okay.
19 to Monday.
19th is
19
verse. Okay.
Percaya atas diri gimana? Ini juga.
Yes.
Your Lordship, I'm appearing on behalf of the petitioner. And Lordship, considering the present scenario and recent incident which has happened between the respondent and the petitioner, we would like to follow and maintain the status quo which has been passed by the learned executive magistrate Itanagar. So we wish to withdraw the matter so that peace and stability is maintained between the parties, Your Lordship, with the liberty to refile the matter.
With the liberty.
In case if anything arises between the party, we can approach any appropriate court, Your Lordship.
How there will be a liberty, Your Lordship? That will be a fresh cause of action.
No, just a minute. What was the order earlier?
Your Lordship, 145 order was passed by the learned executive court, and it was challenged before the district and session court, Your Lordship. There also the order has been upheld.
Okay.
And now by being agreed from that order, they are approaching this honorable court.
Okay.
And there was no any error in the order passed by the learned executive court, my lord.
So what the order says?
Your Lordship, the certain portion of the land in where the possession was with the parties, that has been decided, and the portion of the land which is disputed and there was no any record as such for that particular plot of land, they both the parties were directed to maintain status quo and approach the appropriate court, that is the civil court.
Okay. So that means you have to approach before have you approached the civil court? Not yet.
Yes, Lordship, actually we have approached the session court.
No. After, okay, so after that, they approach the civil court.
No, my lord.
Not
They
yet,
have
not
not, no, they have not exhausted that remedy.
Okay, that, because the status quo order is there.
Yes,
In your,
yes,
in your favor or in their favor, in both, in favor of both the parties. So with that, that will remain as it is unless you challenge it or unless you file before the civil court.
Yes, absolutely, your lordship.
So you have, that means not yet exhausted the remedies. You have to take, you have to file before the civil court after withdrawal, not before this immediately. And then probably you may have to file before the civil court only.
And yes, and one more aspect is there, my lord. In 145 proceeding, the status quo order has been passed.
Yes.
If they don't have any issue, they can go for recall of the order also.
Right.
The one under 145, the remedies itself they are in the 145. So there is no any question of your lordship giving liberty for this present case.
Liberty is not required because status quo is already there. And then because giving you a liberty to file before the civil court, that is already there. So no liberty is required here. So what we'll do, that will be supposing if you file before, if you approach the civil court, any order passed there, that will be a new
Subject
cause of
matter,
action.
yes, absolutely.
Okay.
Okay, Lordship.
Okay. Miss
E. Mosang.
Mosang, Learning Council, appearing on behalf. Mosang, your name is not there, isn't it?
My name is Dear Lordship.
Oh, you're there?
Yes.
Okay.
E. Mosang.
Mosang Learning Council for the petitioner has an instruction to withdraw this criminal petition. Okay, this petition.
Lordship made a submission like with regard to maintain the peace and stability between the parties.
That
may
is
be
already there. No need to
reflected-
interfere there.
Like
That is
humble
already-
submission may be reflected in the order copy.
How that can be, your lordship? That
No, that is already there, I think, in the.
its order is already there, your lordship.
That order itself is like that only. Normally, 145 proceeding, order itself is like that. And then status quo, if it is there, then you have been given liberty.
In fact,
So
your
all
lordship,
liberty you have.
they are assailing that order actually in this criminal petition. They are assailing that order actually.
Shouldn't have actually.
Yes, actually. They are assailing and now they are saying that this from
Actually,
the
you should have directly approached before the trial court from the very beginning, before coming here. No? Okay. Mr. Ete, and you are also representing some
Respondent number 2.
Okay, for the state respondent and Mr.
J. Singh.
Sorry, Learning Council now appearing on behalf of the respondent number 2 has no objection. Okay. In view of the above, the prayer is allowed. That this criminal petition is dismissed on withdrawal. Okay.
yes, your lordship. Yeah, yes. Obliged.
Any stay order here? Okay.
Regarding item number 21 and 22, next date will be better for us 5th of June.
Okay, 5th of June. Okay, they change it for 5th, huh? 5th June. Okay. Yes, Mr. Kaba.
Yes, may I please, Lordship. Lordship, this is a criminal revision petition.
Revision?
Yes.
Civil revision. Civil revision.
Sorry, civil revision, 227, Lordship. Filed by the petitioner against the impugn order passed by District Court Pasigat on dated 11/2/2025. Lordship, the fact of the case is that the petitioner is a local resident of CG, and also the respondent is also from the same village. The petitioner is having an area of measuring 16,000 square meter approximately located at CG village within the district of Lower Siang, Arunachal Pradesh. Lordship, on 14/9/2024, the respondent has made an encroachment upon the land of the petitioner at CG village, due to which the petitioner has approached the village authority verbally, lordship, verbally, for redressal of the grievances of the petitioner with regards to the encroachment made by the respondent. Thereupon, the spot verification was conducted and Kaba was taken up, lordship. But in the meantime, what happened is that when I filed complaint and when the Kaba was taken up, in between, my son has expired. As such, due to my mental trauma, when the Kaba was fixed on 22/10/2024, I had filed a letter that I am unable to appear in the Kaba. So accordingly, lordship, Kaba decision was passed ex-parte, lordship, in total violation of, lordship, section 44 of Assam Frontier Administration of Justice Regulation 1945, and in violation of section 44 of, yes, section 44 of AFR.
When this order was passed?
This order was passed on 22/10/2024. Lordship,
This proceeding before the Kaba was as per the civil code.
yes, as per AFR, as per AFR. But lordship,
And the complaint was lodged when?
lordship, complaint was lodged verbally, lordship.
No, when?
On 14/9/2024.
It was also in the year 2024.
Yes.
It was not reduced into writing. The
No.
complaint.
No, it was reduced in the Kebang order. There is mentioned.
It was
verbal complaint was made.
verbal complaint was filed by the
And the complainant himself was remained absent.
Yes.
On the date of the Kaba.
Yes, lordship. We did.
Whether anyone represented.
No.
Represented.
No,
one represented.
no one represent. And that too.
No record as such, nothing.
Nothing, lordship.
But then Kaba proceeded ex parte.
Yes,
and
lordship.
decided.
Yes, lordship. And even, lordship, the reason has been given that I am in the
Will it take long time?
Yes,
Do we have sufficient time?
lordship, it will take time, lordship, because
It will take just few minutes only because my lord, firstly, our argument should be confined to the order passed by the learned district judge. Whether the order passed by the learned district judge is patently illegal, whether there is patent error in the order passed by the civil judge senior division. This is the only issue before this honorable court. Because we cannot go all the fact, because it will obviously, Your Honor, because in the appeal it will go in the appeal court before the learned civil judge senior division.
Sole respondent.
Yes, yes.
lordship,
No,
three round of litigation has already been gone. That's why lordship,
I think it will take time.
yeah, lordship has to understand the fact of the
And
case.
because I haven't gone through.
Lordship.
And for understanding, even after the fact being narrated.
Lord,
we have to go
lordship,
through
lord
and
provisions,
read the judgment.
lordship, lordship.
If
Lord-
it is going to take more than the time what we have, I think we should. But how we cannot.
Lordship.
My lord, I will take only just hardly 10 minutes, less than 10 minutes.
But lordship,
Because my lord,
being a petitioner, I have to open the case, lordship.
because what is their case is, my lord, ex-parte
My
case
case,
was
lordship.
passed in my favor. Thereafter, we file after getting the order, we have filed a caveat application. Thereafter, they have moved an appeal before against the order passed by the Kebang.
Okay, district judge.
Yes, this no, civil judge senior division, and in the civil judge senior division, we have already filed a caveat, and without giving us the notice, the status quo, the honorable civil judge senior division has passed an order, adverse order to maintain the status quo order, and against that order only, injunction order only, interim order only, we have filed an appeal before the district judge, Pasigat. Thereafter, after seeing the entire record, the caveat was in place. the learned district judge was pleased to suspend the order, thereby allowing us to continue with the agricultural activities, and further directed us not to.
Earlier, thereafter, whether the either of the parties approached before the High Court for challenging that order, it is the same order?
No, this is the order.
This is the only
This
order.
is the same order. Okay.
Lord
So
Sir,
this is, that means this is against the injunction.
Yes.
yes.
Interim order.
Interim order.
Interim order.
Yeah, status quo order was passed without hearing the party, caveator. Caveat, we have filed a caveat application.
Yes.
After getting the ex-parte Kebang order in our favor. Thereafter, they have filed an appeal. Thereafter, the Honorable Civil Judge Senior Division was pleased to pass the order of status quo order without giving us the notice.
Although you are a caveator.
Yes. Then against that interim order, status quo order only, not against the appeal.
Against that interim status quo order has been set aside and passed by the district judge.
Suspended.
Or suspended.
Suspended. Interim. That is also interim.
That suspension.
Yeah. Again. Suspend. That is also pending before the it is only pending. It was fixed on 28 March 2025. It was fixed for written objection, but instead of appearing before the district court, they on 25 March 2025, they have moved the civil revision petition.
When next date is fixed?
Yes, my lord.
Next date is fixed in the.
Now next date is fixed.
It has been stayed.
Yes, they have fixed the date for hearing, but I have not.
There is a stay order in this CRP.
We can agitate all these issues before the learned district judge.
They stay here.
Yes.
So then it will not be proceed.
Yes,
It will
Lord.
not proceed.
Yeah,
It has been stayed.
Yeah.
Okay.
Lordship.
Then for him it is urgent, it appears.
Yes, Lordship. But Lordship,
My lord, the urgency is only that because of the interim order passed by this honorable court, I am not able to enter into my own land, that LPC land, and regarding this dispute is only for boundary dispute, not the entire land. 25,388 square meter is put to because of the order. The
order was.
My lord, last page. 110, page number 110. This is the order passed by the learned district and session judge. My lord, I will only go through the relevant portion only. It will not take a long time, my lord. 110, second last page. Because my lord, since 3 occasions, our item is kept in the last item, so it has been postponing. What after one?
What do you say?
Lordship.
Can you finish it in some 20 minutes?
But Lordship, yes, Lordship, I can try, but Lordship, I have to open the case because there was 3.
We'll take a break for 5 minutes.
Yes, Lordship.
Yes.
Lordship. Let us see, Lordship, if it can be. Otherwise, we'll have to pause it for the next day.
Lordship.
Maybe Thursday. Keeping Thursday, we can just
Lordship.
for hearing.
Okay.
What we'll do, most probably it will not be possible. What we can do is today we'll have a preliminary hearing.
Lordship.
And I'll get it fixed. If we find it that we can dispose of, get it fixed next Thursday. Okay. Thursday or Wednesday, any day. No?
Lordship, may I proceed? Lordship, may kindly read section 44, that is the latest amendment of Arunachal Pradesh Civil Code Act. Lordship, serial number 11, amendment to section 44. Lordship, have you got it?
Yes.
May I read? amendment to section 44 in principal regulation in section 44 after subsection 3. The following subsection shall be inserted. The village authority of the inter-village territorial council or apex council, as the case may be, pronounce or take ex-parte decision if one of the disputing party does not turn up or remain absent willfully for 3 consecutive times after giving not less than 30 days of each occasion or reasonable opportunity of being heard. Lordship, this is very crystal clear. The mandate of this section says that, Lordship, the mandate of section 44 of Arunachal Pradesh Civil Code Act says that either of the parties should at least 3 times notice has to be given to either of the parties before passing an ex-parte order by village authority. And here in this case, Lordship, I have given only one date. That also I have filed a dispense application, Lordship, I should say. That is also reflected in the impugned Kaba decision that I am unable to appear as because my son has been expired, due to which I am not in a sound mental state of health. As such, I am not appearing on that Kaba decision, although I am the complainant in the case. And Lordship, that 3 times also, Lordship, within the span of 30 days, it has to be given. But here in this case, not even within the span of 30 days, the notice has been given from the date of complaint, Lordship. That is prima facie, Lordship, the first Kaba itself is decision has been passed illegally, arbitrarily, in violation of the mandates of the section 44 of Arunachal Pradesh Civil Code Act. As such, being agreed with this Kaba order, I have filed an appeal, Lordship. And I have filed an appeal before the Civil Judge Senior Division Pasigat. Upon hearing of my appeal, Civil Judge Senior Division has just passed an status quo order. In that status quo order, Lordship, just now my learned friend has said that he has filed a caveat and he was not given an opportunity of being heard. Lordship, that is a wrongful submission. Lordship, I am clarifying that issue. Lordship, may kindly read page number 18 of my petition. Page number 18, annexure 2.
Yes.
Has the Lordship got it? Order dated 26/11/2024. This is the Lordship Civil Kaba Appeal number 28/24 along with caveat petition 6/24. Here in this case, I am the petitioner in the Civil Judge Senior Division, Lordship. Lordship, the order reads that case record put up today in view of Civil Kaba Appeal number 28/24 filed by the applicant Sri Sengo Taipodia against the respondent Mr. Henley Riba for quashing and setting aside of impugned ex-parte Kaba decision 22/10/2024 passed by the CG Village Authority against the appellant. Learned counsel so and so appeared in appellant is present. Heard learned counsel perused the application and seen that a caveat petition number so and so has been filed by the caveator prospect respondent so and so, who is actually respondent in the present appeal. Lordship, now this is the relevant. Learned counsel Mr. O. Tamuk for the caveator is present, praying for issue of notice to the caveator. This means, Lordship, the counsel for the caveator was already present. Then what is the use of issuing a notice? Now my learned friend is saying that.
Just a minute.
Lordship.
Learned counsel for the appellant is present.
Yes, he was present.
Peruse One that is for appellant only. Assume that the capital functions will be fine. Oh, Tamuk was present.
Yes, Lordship. He
Oh.
was present. Lordship, I am reading further, Lordship. Heard and seen, heard and as the counsel for the respondent, Mr. Henley Riba was also the caveator is present today, Lordship. Copy of the appeal memo along with IA to be served immediately. Learned counsel for the appellant submits that the appellant has started clearing the land and in the interest of justice prayer is made for suspension of the operation order of impugn Kaba dated Kaba decision for IA number 88/24 has been filed. Heard and as the caveator respondent has appeared through his counsel today, there is no further need to service notice regarding the appeal. Hearing this order, the learned trial court has rightfully observed that when the party for the caveator is appeared personally, then what is the use of?
Okay, just read the order.
Yes. In the meantime, both the parties are directed to maintain status quo with regards to the suit land. No party shall carry out any further construction, cultivation, or enter into the suit land till the next date. Furnish a copy of this Kaba order to the chairman for information. Appellant to take step. Fix 5/11/2025 for filing of affidavit objection to IA. Appellant to take step. This is the order. I have challenge against the impugned Kaba decision dated 22/10/2024. Lordship, citing the ground. Lordship,
It appears that the council was present.
yes, Lordship, he was present very much, Lordship.
My lord, so your submission would be a little difficult.
Misleading submission, in fact, Lordship.
This is totally not a misleading submission. I'll come to that also. Let it submit thereafter.
Okay.
I'll submit.
So,
My lord, what has happened? Only this question I will clear it. This issue, my lord. Because the council, my lord, if we see the O Tamuk, the council O Tamuk, he happened to see that Sengo typo there versus this
okay.
Henley typo
Anyway,
there.
let him complete. Anyway, let him complete, huh? Okay. Please, Mr. T.
Yes. Lordship, my appeal petition number 28/24. Lordship, here in this appeal also, I have taken the ground of page number 40. 40 of main petition, page number 40.
Just a
40.
minute, just a minute. Huh? So when this appeal,
now,
just a minute.
Yes.
Next page.
Yes, Lordship, prior to that, Lordship, I'm taking this Lordship to page number 60. That is the minutes of impugned Kaba decision.
16.
Yes, 16. This is the translated copy of Kaba decision dated 22nd October 2024. Lordship, may I read? Today on dated 22 October, a Kaba was held under the chairperson of so-and-so in presence of jury member so-and-so. On dated 22nd October, a Kaba Parwana was issued to Sengo Taipodia, son of so-and-so, was asked to attend the Kaba to settle the boundary dispute regarding the land at Chiku Hunko Chatu Rijo of CG village. under the chairmanship of so and so, and in presence of the jury member, PRI members, and
Now, where they have referred that complaint was received from?
Lordship complaint was.
Is there any earlier order than?
No, Lordship, there is no any written complaint.
Then any parwana issued?
Yes, Lordship, on the basis of my verbal complaint dated 22nd October 2024, Lordship.
No, you lodged complaint on which date you said?
Sorry, Lordship.
It was not on the
14 September. 14 September.
Where do we find that?
Lordship, I am coming to it. That is, Lordship, point number 1 of Kaba decision.
Okay.
Yes, because Lordship, I have given my complaint verbally, because Lordship, in the villages, verbal complaint and all, as per practice, it is applicable there. So Lordship, the point number 1, dated 14 September 2024, Sengot Taipodia verbally.
Where are you reading?
Lordship, page number 16, 16.
Okay, yes. Today, just a minute.
Yes, Lordship, down below, point number 1.
Who is Sengot Taipodia?
I am Sengot Taipodia, the petitioner in the CRP. Lordship.
And Henley is?
Henley is him, the respondent, sole respondent, married. Lordship.
Just a minute. Yeah.
Lordship.
Okay. Okay.
Yes.
Dated.
May I please. Point number 1, dated 14 September 2024. Sri Sengot Taipodia, that is me, Lordship, verbally complained Sri Kirkar Taipodia that Kirkar Taipodia is the village authority or the HGB.
What authority?
Sorry, Lordship.
What authority?
Village authority.
HGB. Okay.
Yeah, village authority is HGB, Lordship. That Sri Henley Riba has encroached his land. Therefore, on 18 September 2024, a spot verification was done by the villagers of CG village. After that, both the parties came to the conclusion that Robok 3 stamp was boundary, so the villagers made a proposal to find Robok 3 stamp and postpone the Kaba meeting. On dated 3/10/2024, again a Kaba Parwana was issued to the same party for the same subject, but Sengot Taipodia submitted a letter to HGB CG to postpone the meeting as he was not at peace mentally. Sri Hengo Taipodia on dated 30/9/2024 complained Deputy Commissioner Office against Sri Henley Taipodia after Office of the Deputy Commissioner issued a forwarding letter to HGB to conduct a meeting. Today on dated 22nd October 2024, a Kaba Porna was issued to same parties for settlement, but Henley Riba was present and Sengo Taipodia did not attend the Kaba meeting. The members present did the spot verification in absence of Sengo Taipodia, and after the verification of the said land, Chiku, Hunko, Chaturijo, it came to the conclusion that the plot of land belonged to Henley Riba. Also, the boundary claimed by Sengo Taipodia was also found to be misleading. Witnesses, so and so. Lordship, this is the main Kaba decision. Lordship, by reading this Kaba decision, it is prima facie crystal clear that the Hengo Taipodia was not present, with a reason that I am not able to appear on the said Kaba date, with a reason, Lordship, they have also received a letter May I take Lordship to page number 67 of my CRP?
So in absence of the.
Yes.
The appellant.
Yes.
The Kaba visited.
Yes.
The spot.
Then how I can place my grievances? They have done arbitrarily, they have done illegally, they have done as per the whims and fancies, Lordship. Lordship, in total violation of Article 44, Section 44 of Arunachal Pradesh Civil Code Act, which says, Lordship, after receipt of a complaint, verbally or in written, at least 30 days has to be elapsed. Lordship, the law says 30 days has to be elapsed. But here in this case, the village authority was in such a hurry on receipt of the complaint prematurely. The law says that 30 days has to be expired, but this village authority, on the behest of the respondent, Sri Henley Riba, he has taken up the Kaba decision, and without hearing me, he has passed the Kaba decision and has handed over or given the said suit land, which is my ancestral property, which is in my possession, to Henley Riba. During that time, I was already in mental trauma as because my son has been expired, Lordship. Page number 67, Lordship. Sorry, Lordship, page number 40. Page number 40, Lordship.
No, 67 is the application for.
Yes, 67 is
adjournment.
This is different application. Page number 40. Lordship, here also in my appeal against this Kaba decision, impugned Kaba decision, I have made an appeal before the Court of Civil Judge Senior Division under section 96, read with order 41 of CPC, read with section 15 of Arunachal Pradesh Civil Courts Act against the Kaba judgment and order dated 22/10/24 with a ground that this Kaba has been decided arbitrarily and in violation of section 44. Lordship, I have in page number 40, I have clearly stated ground of appeal that this Kaba decision dated 22/10/24 is unjust, malified, arbitrary, and untenable. The impugned Kaba decision is in violation of statutory mandates of section 44 of Assam Frontier Regulation of Act 1945, wherein the procedure of hearing of the case of the village authority is provided under section 44 is reproduced herein under. Section 44(1), all suits tried by the village authority shall be decided in an open darbar in presence of the parties and at least 3 independent witnesses. Here, the other parties was not present. This is the Lordship governing law applicable to Kaba. Number 3, after hearing both parties and their witnesses, if any, the village authority shall forward pronouncement of decision. This is also violated. That the village authority or the inter-village territorial council or the apex court, Lordship, those are the words. In some places, it is been called as village authority, apex court, bango, etc. But the meaning is same. That is HGB or village authority. May pronounce or take ex-parte decision. Lordship, only in this case ex-parte decision can be taken up. If one of the disputing party does not turn up or remain absent willfully for 3 consecutive times. Here in this case, I remain absent only once. That also with a reason. willfully for 3 consecutive times after giving not less than 30 days on each occasion of reasonable opportunity of being heard. Lordship may kindly see the complaint date also. This means from the date of receipt of complaint, at least 30 days should be given. But here in this case, not even 30 days was given. It was around 18, 20 days something time was given, and the decision was taken hastily. As because the village authority is a close relative of Henley River, Lordship. As such, considering those facts and circumstances and on reading the face value of this Kaba decision, the learned appellate court, that is civil judge senior division, has rightfully, Lordship, state the Kaba decision by passing a status quo order, Lordship, only by passing a status quo order. And Lordship, status quo order dated 26/11/2024, which I have already read before this Lordship short while ago. Lordship, hearing this status quo order, they have again filed an appeal before the district court Pasigat, assigning that status quo order status quo order was not made in my appeal. Lordship, status quo, the only ground is, and secondly, they have filed a caveat, but they have not been given an opportunity of being heard. Lordship, regarding the second point of caveat, I have already submitted before this honorable court that their counsel was very much present. Then what is the purpose of issuing notice? So that point also your Lordship dismissed. And secondly, Lordship, they have in their appeal before the Learned District and Sessions Court Pasigat, they have stated that the prayer for status quo was not there. Lordship, the status quo is a judicial order, Lordship. And my submission to with that regard is that prayer for status quo order may not be required, Lordship. There is a judicial order of a court. It can be passed, it can be invoked by any judicial officer or a court, Lordship. So that is the only reason, that is the only ground they have filed appeal before the District and Sessions Court Pasigat. Thereafter, Lordship, District and Sessions Court Pasigat has passed an order staying the operation of the order dated 26/11/2024 passed by Civil Judge Senior Division. Lordship, page number 108. Annexure 4. This is the impugn order which I have challenged and filed this CRP before this honorable court. Lordship, may I read the order? Page 108, Annexure 4.
Yes, this is impugn order.
Yes, Lordship. Impugn order dated 11/2/2025. This is an appeal. Lordship, before this, I also would like to mention before this honorable court that they have just filed an appeal without an IA for stay of the case, Lordship. They have not filed an IA under order 41 for stay of the suit. They have just filed an appeal. They have not even filed an IA for stay. This is the order in Civil Appeal number 8/25. Above there it's written. There is no any IA. Lordship, actually this order has to be passed in the IA, not in the appeal. Main appeal, it has to just notice has to be issued. But they have the Learned Court, District and Sessions Court Pasigat has passed an order in the appeal, not in the IA, because there was no IA, Lordship. Order dated
No-
11.
No
to-
IA for stay
Stay,
petition.
yes, Lordship.
No stay petition.
Yes. Stay petition has to be there, Lordship. This appeal is filed by the appellant Sri Henley Riba under section 15(2). This appeal itself is defective. Lordship, again, I am coming later on, I'll again come to 15(2) of Arunachal Pradesh Civil Court Act 2021 against the impugned order dated 26/11/2024 passed by the learned Court of Civil Judge Senior Division Pasigat, heard Mr. So-and-so, learned counsel for the appellant. The case of the appellant is that the land possessing certificate dated so-and-so, they are saying that they are having a land possessing certificate, but Lordship, in the impugned Kaba decision of 22/10/2024, Lordship, there is no any whisper of LPC, Lordship. Now they came again with LPC. In the Kaba decision, they have conducted Kaba with the village authority. In that Kaba, they have never mentioned LPC. Now they are producing an LPC, claiming that this LPC, the authority has issued LPC. But here in this case, it is pertinent to mention that, Lordship, this LPC was also obtained illegally, fraudulently, against which I have already filed a complaint, because, Lordship, for obtaining an LPC, Lordship, the boundary owner's signature has to be there, but this person has not even obtained the boundary signature, and he has fraudulently put the signature of the boundary owner, and for which we have already filed a complaint before the Deputy Commissioner, and the hearing is pending. Now he has come with another ground that they are having an LPC. LPC dated 25/2022. But this LPC, if they come before the village authority with a clean hand, then what is the impediment for producing this LPC before the Kaba authority? But they have not done, because they thought that his misdeeds will be exposed before the Kaba authority. In respect of land measuring 25,388 square meter, situated at Chiku Rijo of CG village, was issued to the appellant on 14/9/2024. The respondent lodged a complaint before the village authority of CG. Accordingly, notice issued dated 18/10/2024 was issued by the Kaba authority. Let's say here also it is pertinent to mention that the dates 14/9/24 was the first complaint, and 18/10/24 is the notice, that is the Parwana notice issued to me. That means 30 days has not even been elapsed here also, Lordship, which section 44 mandates that 30 days should be elapsed. The Kaba found that the claim of the respondent is misleading and decided the matter ex-parte in favor of the appellant. The respondent filed civil appeal number 28/24 before the learned civil judge senior division for setting aside the ex-parte Kaba decision. The respondent also filed an interlocutory application. I have filed interlocutory application, and upon hearing of my interlocutory application, the status quo order was passed for suspension of the Kaba decision dated 22/10/2024 till disposal of this connected appeal. Anticipating appeal by the respondent against the Kaba decision dated 22/10/2024, the appellant filed a caveat petition bearing so-and-so, number so-and-so, so-and-so, was taken up by the civil judge senior division. By the order dated 26/11/24, the learned court observed that the caveator was represented by learned counsel. Lords, here also again the second appellate court, that is district court, has made a clear observation that learned counsel for the caveator was present, and therefore the copies of the appeal memo along with to be served immediately. Surprisingly, both the parties were directed to maintain status quo with respect to the suit land. It was further ordered that no party shall carry out further construction, cultivation of either in or enter into the suit land till the next date. Being agreed with the Kaba decision dated 26/11 24 passed in civil Kaba appeal number so and so. The present appeal has been prepared under section 12(2) of APC, that is Arunachal Pradesh Civil Code Act. Mr. Singh has submitted that the impugn order has been passed in total violation of mandate of caveat. When the caveat has already been filed, the appeal should have been heard before passing any order. In the present case, the status quo order was passed even before the appellant was served with the appeal petition. Therefore, he has no opportunity to place appropriate reply to satisfy the court. Also, in the appeal, there is no specific pleading for status quo. Lordship, there are two grounds. The only two ground is that they have not been heard and there was no status quo order in the appeal against Kaba decision filed by me, Lordship. It is settled principle of law that when no prayer for particular relief is sought for and no pleading is there to support such relief, and when the opposite party has no opportunity to resist such relief, the court cannot grant any relief. Further, the IA filed by the respondent, there is no specific prayer for status quo. Your Lordship, they have in fact contradicting their own stand, Lordship, here. Firstly, they are saying that there is no prayer in the IA for stay of operation of Kaba order, but their appeal is not even with an IA, Lordship. They have no IA for stay under Order 41. Further, Learned Council has further submitted that the appellant is only carrying out agriculture activities which does not substantially alter the nature and condition of the land. There are standing vegetables on the agriculture. This is also completely a new fact, which is very astonishing to know that, Lordship. Learned Council has further submitted that they have agriculture activities does not substantially alter the nature and condition of the land. There are standing vegetables and other agriculture plants which are on the verge of decay and waste due to the impugn order. Also, the appellant has invested huge amount of money and labor carrying out agriculture activities in the land. If he is restrained from entering in the land, the aforesaid agriculture product will not in time to collect, which cannot be compensated in any manner. For the aforesaid reason, the appellant has asked for interference. I have gone through the order dated 26/1/2024. The order itself revealed that the caveat was already in place and the status quo order was passed before the memo of appeal and the IA was served to the appellant. Also, there is no specific prayer for status quo either in the main appeal or in the IA. Further, no order has been passed in the IA. Two things emerge from the aforesaid paragraph. First, there is a violation of natural justice by the learned court has not afforded a reasonable opportunity of hearing which has been potentially of resulting in miscarriage of justice. Secondly, the learned court has granted relief to the appellant without there being a specific prayer and pleading to support such prayer. Further, it appears that the appellant is only carrying out agriculture activities, and if there is possibility of irreparable losses which cannot be compensated by the monetary damages and which has also adverse bearing on the respondent. In view of the above order dated 26/11/24 passed by the learned civil judge senior division, Pasighat is suspended under further order. Issue notice to the respondent. The appellant shall take step. This is the observation, and they have stated the order of learned civil judge senior division, Pasighat, order dated 26/11/2024. Lordship, this order apparently there is a perversity in this order, as because caveator was already present. And secondly, before the second appellate court, that is district court Pasigat. They have again come with new facts that there is a standing crop. But in the Kaba, there is absolutely not at all mention of anything. They are just confined to one robok tree, Lordship. They have nothing of that sort has been mentioned. In fact, like they are misleading before the district court Pasigat, Lordship. And somehow they have managed to obtain this order. However, by filing this appeal, this honorable court has appreciated the case of the petitioner by considering those material on record, and they have also stated the operation of order dated
Where is the order of?
11/2/2025. Lordship, again, Lordship, I have some more submission to be made. Lordship, they have filed this appeal.
Order of the civil judge.
Lordship, order of the civil judge is page number 18.
Just a minute.
Yes, Lordship.
By which order this court stayed?
Lordship.
24(3). Okay.
Lordship, again, page number 22, Lordship.
Page
22.
What is that?
Lordship, page number 22, this is the appeal memo filed by the respondent as a appellant before the district court Pasigat, Lordship. This appeal has been made under section 15(2) of Arunachal Pradesh Civil Court Act 2021. Lordship, may kindly note it down, Lordship. And Lordship, again, Lordship, page number 108, that is the impugn order which I have challenged before this honorable court, Lordship, 108. Lordship, it is a settled provision of law that quoting and misquoting of the section may not be fatal. But Lordship, here in this case, the learned appellate court, that is district court Pasigat, has also not, Lordship, not has seen or not has taken judicial note of section 15 subclause 2, wherein they have made the appeal. Lordship, this is completely incorrect, Lordship. May I take to section 15 subclause 2 of Arunachal Pradesh Civil Court Act?
Have you annexed?
Lordship, I have, Lordship, I have made my submission. In my pleading, I have, yes, of course, I have made.
Have you annexed
this
civil code act?
No, I have not, because this is a statute. It may not be annexed, Lordship. Statute may not be annexed, Lordship.
You have a copy?
Lordship, I'm reading first. After that, I'll give, Lordship.
Okay.
Section 15(2), appeal from the decree and order passed by the Court of Civil Judge Senior Division in original suit and proceeding of civil nature which shall be such appeal are allowed. Lordship, page number 15. Lordship, page number, sorry, section 15 subclause 2. This is the provision under which the respondent as an appellant has challenged the order of civil judge. Lordship, may I read, Lordship?
Yes.
Lordship, section 15 subclause 2 talks about the appeal from the decree and order passed by Court of Civil Judge Senior Division. But here in this case, yes, Civil Judge Senior Division in original suit, Lordship. This is not an original suit, Lordship. I am again, Lordship, taking back, Lordship, to the order dated order dated 26/11/2024, page number 18, Lordship. Page number 18. Page number 18. Lordship, the mandates of section 15 subclause 2 is appeal is a appeal. That part is correct, but from the original suit. But here in this case, page number page number 18, that is order dated 26/11/2024, which was the impugned order for filing of this appeal by the appellant Senli Riba, the respondent in this CRP, is not original suit, but it is a appellate order. It is a appellate order. Original suit is Kaba decision. Lordship, has I able to clarify, Lordship?
Original?
Lordship, this talks about the appeal from decree or an order passed by Civil Judge Senior Division in original suit. That means if there is an original suit pending
By
in
the Kaba.
No, Lordship.
It was by the Kaba.
Yes, Lordship. This is an appellate order, Lordship. What I mean to say is that, and what the mandate of law is that, if there is a original suit or original order passed by Civil Judge Senior Division, then under section 15 subclause 2, they can appeal. But this is an appellate order of Kaba. Lordship.
Just a minute.
Yes, Lordship.
It's from the decree. Order. Okay, so according to you, the order passed in the appeal.
Yes. This is they have filed appeal under section 15 subclause 2, but section subclause 2 is, Lordship, only they can invoke section 15(2) had there been an original decree passed by decree or order passed by the
Not in the order passed in appeal.
no, no.
I think we'll have to clarify this also.
Yes, Lordship. There is wrong.
It-
Wrongly they
it-
have
it
filed.
involves Law point involves. Let us see.
Yes, those are
Okay.
the law points.
We'll fix it on Thursday.
Lordship.
Okay. Thursday or Wednesday, Wednesday list not yet prepared.
Lordship.
Then
Lordship, on 28, we'll take our both
28,
convenient,
is it?
convenient date, Lordship.
Okay. '28. My lord, if I may, I may
Lordship,
submit.
there is a prima facie, there is, Lordship, I pray that it may be, Lordship, set aside, Lordship. There is crystal clear, Lordship. They have no case.
Anyway, he has also, of course, let us give.
And
him also.
Lordship,
We
they have not
case
even filed any
according to his-
reply. Of course, it's not mandatory, but they have not even filed anything. They have not filed any reply. They are just making an oral submission. They have not filed any reply.
My lord is aware in the civil revision petition.
But at
everything
least
is
to
the
bring on
record.
record.
Why should we file-
Revision petition.
Yeah, doesn't require reply. Because
At
on
least
the-
to
on the- on-
bring on record, Lordship.
Everything is on the record only. On top of the record, what will file? Then according to you, he has exceeded the jurisdiction.
Yes, Lordship, exceeded jurisdiction. Without jurisdiction,
My
the
lord,
district.
under the Civil Procedure Code, under the Arunachal Pradesh Civil Code Act, it is Civil Code only CPC. It is applied, but under which provision of the law under the Civil Code Act 2021 that the original suit has to be filed in the civil court.
And Lordship, there is no stay petition also, Lordship. It may also be kindly noted it down. There is no stay petition.
In the appeal,
Order
then
41.
in the interim, we have seek for interim relief only.
No.
We have not asked for permanent relief, and the interim relief can be asked in the
For that, there is a
appeal also.
specific provision under CR.
If my brother is submitting, then
Land Council for the petitioner. Also had Mr. Humble. Land Council appearing on behalf of the respondent staff. So this will be on 28.
Lordship, yes, 28.
On the request of the parties, let the matter be listed again on 28.
In the meantime, status quo may be continued, Lordship.
My lord,
Interim to be continued. Interim order pass earlier.
Order pass earlier shall continue.
Yes, Lordship.
Okay.
Lordship.
Till returnable date.
No,
Till
Lordship.
then.
Yes.
My lord, this matter may be listed on top of the list because in the last item we are having shortage of
On
time.
28. Today is 19.
Today is 19. On 28 we can have as part item.
We'll take up.
Since many occasions, Your Honor, because, my lord, because of the matter being taken up in the last item.
To be listed on the top of the.
In fact, there is no urgency yes, because status quo is being maintained by.
Urgency
both
is there,
the
that is
parties.
why, because my brother is enjoying the film. He want to delay the process.